dalyviai. Sveiki atvykę į tarptautinę praktinę konferenciją Mediacijos sėkmės istorija ir jos kaina. Nacionalinė teismų administracija organizuoja šią konferenciją įgyvendinant ES ir Lietuvos lėšomis finansuojamą projektą taikinimo tarpininkavimo mediacijos sistemos plėtra. Šį renginį moderuoja Lietuvos apeliacinio teismo teisėjas, teismo mediatorius, daugiametės teisminės mediacijos komisijos pirmininkas Arūras Driukas,
long-term chair of the committee, and the director of the National Court Administration, Natalija, Kaminskienė. Today we will hear the presentations from as many as 5 countries: Norway, Belarus, Lithuania, Italy, and the Netherlands. Arūras, do you know that as many as 700 people have registered this conference? Well, I didn't know that, but it's good news. I believe that's a blessing in disguise. And it's good news that we managed to gather so many people who are interested in mediation, and it also shows the relevance of the topic. It's relevant for the lawyers and people who undergo the proceedings, and they will know that there are alternatives to the cases, to the trials, and they will know more about the possibilities to use different ways of the dispute resolution. It's an impressive conference, an impressive event, because it will also be broadcast via the YouTube channels in both languages, English and Lithuanian. So it will be quite an interesting event, and we're very happy to announce it opened. And we give the floor to the chair of Civil Case Division of the Supreme Court of Lithuania, Sigita, Rudėnaitė, who will give a welcome speech. Good morning. I'm very delighted to welcome you on behalf of the legal community. I want to thank people who made this conference happen. The conditions and the format is unusual, but the period we've been experiencing highlighted the non-judicial dispute resolution and its meaning, as well as the necessity. During the pandemic, we encounter the challenges in all areas of our lives, not only in the life of the state, but also in our routine lives, including the problems, challenges in the fields of medicine, law, and others. We encounter psychological uncertainty, resistance, conflicts, and disputes in different fields, including business. And we will have to deal with those conflicts. And I mean not only the courts, but also other institutions. And here we shouldn't forget the mediation, which is an alternative to the usual dispute resolution methods. When we speak of mediation today, I think it's quite a new method to resolve the disputes, not only in Lithuania, but also in other countries, and it's been applied for several decades now. The main idea is to have an amicable solution, to have an amicable resolution of the disputes, and the idea has been quite old. And the main idea is do not cut something that you can untie, and there are many other sayings and proverbs that reflect the essence of mediation. And it's the main characteristic of mediation, not only in Lithuanian society, but also in other countries in one or other way. It's a collective experience of society, and this wisdom, the wisdom is the main word that should be the key word when we speak of mediation today. Wisdom, both in selection, both in results, in terms of results, is one of the most meaningful definitions or descriptions when we speak of mediators. They are professionals. They have to be wise in managing the conflict. Both from the theory and practice, we know what the advantages of mediation are. Here we speak of resources, of human resources that mediation helps to save. When we can say that it's a cheaper way to resolve the dispute, but it also lifts the burden of the courts when it comes to the caseload for the courts. But the main advantage of this phenomenon is social peace. And here we do not speak only of the legal peace or legal settlement or conciliation. We do not ask why mediation. We ask what is better, how to make mediation better and more efficient, more effective. There are two ways. It's empirical way to reach an agreement on account of our mistakes, and the other way is to ask others who know better how to solve the problem. I believe the main idea, the main added value of this conference is sharing our good experience, sharing our good practice, raising questions, and search for solutions. I wish you all fruitful and interesting discussions, to have more good faith and more amicable resolutions of our disputes that we encounter in our everyday life. Thank you.
Dėkojame gerbiamai pirmininkai už tokius įkvepiančius žodžius. Ir antrąjį sveikinimo žodį norėtume.
Thank you for such inspiring presentation. And now the floor is given to Jurga Greičienė, head of the Judicial and Civil Law Group. Dear guests, thank you for this opportunity to address you on the part of Minister of Justice and address you. This constitutional right is guaranteed for everyone, but we are also looking for new ways to defend our rights, and everybody is now in agreement that this process, extrajudicial manner, is less expensive and less efficient. And sometimes they are allowed to achieve even more, not only defending one's rights. And it's becoming even more popular in family cases. This conference is dedicated to discuss the success and the experience in practicing mediation. And we are happy to see the opportunity to share our experience with representatives from foreign countries who will also be telling us about their experience. In Lithuania, if I'm not mistaken, we started speaking about mediation in 2005, but of course the breakpoint was the coming into effect of the new law on mediation. It is clear that not only the legal regulation is important, but also the implemented measures, this mediation code, and the ongoing professional development. It is the entirety of those measures that made the issue very most popular. In 2015, we had 53 civil cases, and in 2019, we had 533 such processes. Starting from 2018, also with the help of European funds, grateful to them, we are implementing this development project. This conference helped to provide training to 420 persons. We developed the mediation subsystem and were engaged in dissemination of information about mediation. As a result, today in Lithuania we have 528 mediators who are able to provide most qualified services. All the measures in their entirety allowed us to step into a new stage, that is to introduce the mandatory mediation, which is an opportunity to everybody to settle their disputes in a more efficient way and faster. This year, we also approved another initiative of the Ministry of Justice starting from 2021. This extrajudicial mediation will be allowed in administrative disputes. And I hope that for all of us, this, due to our efforts, will contribute to the further development of mediation and will be very helpful to the society. Everybody knows the story about an orange. You can see an orange that I'm holding in my hands. And everybody knows the story about an orange and two sisters. Like two sisters and one orange, and there was a dispute how to split it. Most would say just cut it in half, and that's going to be fair. But after this decision was taken, none of them was happy, because one wanted juice and the other wanted the pulp of the orange. So, as it has been mentioned, the wisdom, the insight, the opportunity to look at the bigger picture are the most crucial factors in the success of mediation. So, thank you very much for your attention, and I hope the fruitful discussions and interesting conference. Thank you for your welcome words. We are really happy to see this partnership with the Ministry of Justice in implementing such beautiful ideas as mediation. Taking advantage of the privilege of a mediator, I would like to say a few words about some practical aspects of our conference, online conference. As I've said, the conference is being broadcast on YouTube in 2 channels, in Lithuanian or English, so you can choose the channel to which channel you would like to listen. Also, there is an opportunity to everybody to place questions in writing, both to the moderators and to the speakers. The most interesting questions will be broadcast and will be forwarded to our speakers. Every speaker will have 15 minutes for the presentation, and 15 minutes will be for Q&A session. In our office here, we are now keeping a safe distance, and we're happy to feel that our conference is arranged in a safe way. And we'll have 3 breaks in the course of our conference, and you are very much invited to stay alert with us in the course of the entire conference, because we're going to have very interesting discussion afterwards.
And I'm happy to introduce Rimantas Simaitis, our first speaker. His main titles are very noble, but we shouldn't forget that he's a very active young man. And maybe it wouldn't be appropriate to call him the patriarch of mediation in Lithuania, but he was the pioneer in this field, as since the very beginning he was very active in the field of mediation. He works in the Faculty of Law. He has a course on mediation in civil disputes. He's an arbiter, he's a mediator, a lawyer. He's the head of working group for mediation. He's been working there since 2015. He's been taking part in many working groups for drafting laws, and he's been involved in drafting the law on mediation as well. The topic of his presentation is Lithuania's progress in the context of the development of European mediation system. So, dear Rimantas, the floor is yours. Good morning. Can you hear me well? Excellent. First of all, I want to thank the organizers of the conference for this idea for successful event, for the implementation of this idea, for making this true. And I can see there are many guests that have registered with the conference. And I will tell you about how we managed to reach this success in the field of mediation. I want to speak of the progress of Lithuania in mediation, to make it more integrative, and to assess how Lithuania is doing in the context of the European mediation system. I will show you these slides as well, but as an introduction, I want to share an insight with you. Lithuania has made a huge progress in the field of mediation, and I agree with Jurga Greičienė that in 10 years, in 5 years, since 2015, in 15 years, since 2005, with the help of Mr. Driukas and other colleagues, we launched a pilot mediation project in the courts of Lithuania. We had training for the very first mediators, and this also reflected the attitude of the states as to how the mediation could be used in our law system, in our court system. There have been many attempts supported by the European funds and foreign funds, but they haven't been as successful, or they haven't been raised to the national level, to the level of the states, but they have become part of formation of the law in Lithuania. There were ups and downs, but in 15 years, we've made a huge accomplishment. Maybe we couldn't call it an astounding success. We should go for higher results. We should aim for higher results, and maybe the initiative, the recent initiative, has shown that there's lots to do in the future. But we can define the progress in Lithuania as a little miracle, because investments in the mediation progress, when compared to the investments to the core development and maintenance, as well as the maintenance of other institutions, are very modest indeed. When it comes to the mediation project, to the pilot mediation project, we had a very small budget, only several thousands of euros. So when it comes to such amounts, and when we discuss such amounts with our foreign colleagues, raise their eyebrows, they are very, very surprised, and they always ask, how did you manage to do that? So the very first results were not as surprising, but now we can see that in 15 years, the results have developed into quite a stable mediation system, which is now used in all systems of the courts, and it's quite an engine in the legal system of Lithuania. So the main idea is that mediation is characteristic of quite small investments, and that the small investments can mean huge progress, huge breakthrough, not only in Lithuania, but in other European countries as well.
How does
it manifest itself? Well, the mediation as a phenomenon, when we discuss it with our foreign colleagues, should be approached in a broader sense, in a broader context. It is integrated in the whole system, in the whole ecosystem of the courts. It has advantages and disadvantages, of course, but the development of mediation and the goal of development is to inspire, catalyze, and shape the tree of mediation, which can bear fruit, and it can be really efficient. How are we doing in this particular field? Well, it can be assessed through different parameters. What goals can we set? And what results do we want to achieve? Well, we can use the AAA methodology, which comes from the UK. It means accessibility, awareness, and availability. But I believe the combination of these three letters is not sufficient to measure the real success of mediation in the whole system of dispute resolution. We should add other very significant parameters as well. We can see that other parameters are recognized in the academic community, in the scientific community, and we should start with these particular characteristics because it's contributed to the development of mediation, and this is a very smart tool that should be used in many ways. Friendly law, friendly environment is also an essential characteristic. It was also mentioned in the welcome speeches. We've experienced that when we launched the pilot project, and we saw that it has to be not only legitimized in terms of the mediation activity, but it also should help to undergo all challenges. Since the very beginning, in 2005, it also involved science and education. We had to read lots of sources of literature, which were very few in Lithuania. And the most active participants are Vilnius University, Mykolas Romeris University, and there were very, very few articles on mediation. And these were only single initiatives. There were some mediator trainings organized, but they were related to private entities, but it was not a massive phenomenon. What we have today is the fact that two universities are really involved in making mediation more accessible. They train students, they have study programs for psychologists and the students in the fields of other studies. And what we notice in the period of 15 years that the level of mediation is in Lithuania turned into the level of experts, not only listeners in Lithuania. Here we speak of international conferences. We can participate in those conferences and we are able to share our insights and our experience. So this is a major breakthrough in 15 years. Availability and quality. Well, after the preparation for the project of legal mediation, we were able to count as many as 20 mediators only. And today, we have 528 mediators who are trained for this work, who took exams, and so on. The whole system of knowledge now is expanded into a network that is available in the whole of Lithuania. We also are trying to develop and encourage the progress of mediation in Lithuania. We've accomplished quite a lot. We've seen good initiatives. We can see that the number of mediators is growing. In terms of recognition, well, the situation is okay or more than okay in Lithuania. Well, people who find themselves in legal situations can be offered mediation services, and the subsystem of mediation has been also created. The parties can be given mediation services free of charge, and when it comes to mandatory mediation, this service is offered free of charge to the parties as well. Maybe it's not quite a good quality of mediation, because then the parties start to be naturally scared and think of other things, that the parameters can be changed, that the mediation is not as valuable because it's given free of charge, or if it's free of charge, and maybe then the services should be of higher quality. And at first, the very primary concept of mediation included some fees, some small fees for mediation. But when the collection was discussed, we saw that the positive effects really was justified in other European countries. Well, the very last recast of the law on mediation excluded that idea of collecting fees. So the availability, accessibility is good, but it's too good when it comes to recognition of mediation.
As we can see, in the course of the 15 years, this, in terms of recognition, mediation became much wider recognized. As an advocate, I've been in many court cases. I don't remember the case that in the course of preliminary hearings, everybody was, nearly in all cases, everybody was offered to take advantage of mediation arrangement. And that is very characteristic of most countries, but not only in courts. This mediation can be achieved not only in the judicial stage, but also in pre-hearing stage also. So that is the purpose of mediation. So that is the change was enormous with the first ideas, with our wish to increase the awareness about mediation. We can say that we achieved a dazzling success and progress, but there is still room for improvement. The last parameter, that is, so speaking about the friendly law, I need to say that in 2008 was the first attempt to adopt the mediation law. We were very actively involved in that. The idea was to make the law rather friendly. We also integrated some public resources here, but that did not really justify itself, and therefore certain efforts had to be delayed for a later stage. But slowly, in the course of 15 years, Lithuania Lithuania was developing and maturing, and in 2018 we had a new version of the law. In international experience, very often introduced as a balanced approach towards mediation. I also had a chance to participate in developing the European mediation lawmaking camp, which was approved in European Council last year. The parameters, based on the parameters on that guidebook prepared by European Council, we can say that Lithuania, by some 85%, is among the leading countries, but still there is still way and places for improvement, but whatever our achievements are really impressive. We can speak in numbers also, just to make our presentation more specific. In 2018, the European Council Commission assessed the progress of mediation development in member states. They developed some kind of success index, the parameter that could be used to assess the development of mediation in the specific country, as the relation between mediation and judicial hearing. Unfortunately, Lithuania did not provide its data. I will not speak about the reasons for that, but other countries did. So we can see that this relation between mediation and judicial hearings was very modest in 2017. Many countries were much ahead, like Italy was 11%, Finland 10%. So we need to say that mediation in those countries is much better developed and much more popular. Some other countries did not provide data too, just like UK or the Netherlands, but according to the unofficial data that was available to us, we can say that they would be somewhere in the middle, between 5 and 10%. We can see that in Lithuania we really had the number of mediators these days working in Lithuania is 540, and we believe that we'll be able to increase that index. Maybe not as impressive as we wanted, but we're still on the way to improvement. We are working very consistently, and we can also discuss the importance of that parameter. Speaking about the quality of mediation, and there is a book, The Promise of Mediation by Faulkner. The author of that paper was speaking about the mediation, how mediation works, and was discussing the issue in detail. And one of the most important insights of that paper was that the critical resource of conflict transformation is the party's own basic humanity, the essential strengths, decency and compassion as a human being. That is the basis that gives rise for a possibility to transform from a serious conflict to mediation, and to be able to settle the conflict by way of mediation. That shows how the parties behave in respect of the conflict, how they understand each other, do they have any compassion, and do they respect each other. And it appeared that mediation is able to disclose that. And very often, as the conflict that sometimes seems unresolvable The mediation says, no, there is still possible to achieve some change in this negative interaction, not only by judicial measures, but also by measures as settlement and reconciliation. If some 5 years and earlier we were speaking about the development of mediation, as the purpose of mediation was to release the burden on courts, I can say that recently this approach is undergoing some transformation, as mediation is becoming the composite of the judicial, of the dispute resolution system, and offers a little bit wiser approach. That is, mediation is one of the measures, if it's properly integrated into our system, can provide a wiser method of dispute resolution. And I can say that Lithuania has been quite successful in that, and I believe that we'll be continuing that way. Because this system not only strengthens the position of mediation, but also offers an opportunity to show some new opportunities in the future. I believe that in the future this process will be more automated. It's not in the course of the next several years, but several decades. Mediation with some human touch can produce a very fair and very productive answer as a contribution to the technological aspect, because we have to remember that humanity is the most important aspect of mediation. Thank you very much for your attention, and I'll be happy to answer your questions if you have any. Thank you to Mr. Rimantas for the overview of mediation and Lithuania in the course of the last 15 years. Rimantas, of course, could be speaking for hours about the subject. We still have not received any questions, and I am inviting you to send questions to us so that we could present them to the speakers. My question to Mr. Rimantas is the following. As we looked at the general view of mediation, what is, in your opinion, the most breakthrough characteristic of mediation in Lithuania, and maybe what is the main shortcoming? I believe that in Lithuania we have a very grateful situation because we are a small country. As I mentioned, in the international context, in other countries, significant resources are allocated for mediation. But in Lithuania we have a breakthrough without such substantial investment. Currently, no major investment is coming from private sources, but I believe that this will be a source for further development. Shortcoming is the lack of consistency. Sometimes we hear opinions that mediation is not a priority for a country, or maybe some 5 years later somebody brings an idea that maybe it's a good idea. So mediation is a phenomenon that this consistency and systemic approach is extremely evident. If that is lacking, mediation really suffers. If that is developed, I believe mediation can produce results that will exceed our expectations. If any resources that a little bit more than moderate resources are allocated to this area and just some wise approach is guaranteed, I believe that in some years we'll be speaking about some impressive successes that we can achieve in Lithuania. Yes, that Mr. Rimantas only confirmed that every child needs a very consistent care. If that is not available, every child can go the wrong ways. So we just have to remember that in order to be able to spread our good news about mediation.
Let's move to our next presentation. I can see my colleague online. So the presentation will be given by the judge, Giedrė Jakštienė. She is one of the most active and successful mediators in Lithuania, and she's been involved in this field since the very beginning. And besides a huge caseload, she always finds time for mediation. She's a very warm person, and she's very good at what she does. And Giedrė will speak of the success story of judicial mediation in Lithuania, whether it's a question or exclamation mark. She's a judge and a mediator in Kaunas Court. Thank you. Good morning, everyone. As you heard from the information provided by our moderators, I will speak of judicial mediation. Well, I would like to review the history of judicial mediation in Lithuania, its trends, its increasing popularity and opportunities. What should we do to make more cases of mediation in Lithuania and to have not a single explanation mark, but lots of them? Well, judicial mediation, which has been increasingly popular in Lithuania, is still an unknown location in Lithuania, but its success stories are more frequently seen in the media, and the efforts of our lawyers are fruitful. There are more and more amicable settlements with the help of mediators in Lithuania, and the parties to litigation always save time and money that would be required by the proceedings. And in many cases, they have no animosity that would be dictated by the judgments of the court. We should discuss the compromises, and when we speak of family cases, we know that in the courts, family cases are heard for a period of 2 or 3 years. In the mediation, parties seek compromises which can be reached in 2 or 3 sessions. Of course, they do not take 1 or 2 hours. They could take 3 or 4 hours, but time-wise, it's more expedient, it's faster, it's better, it's more advantageous. And in terms of finances, when families, let's say, when people want to divorce, when they have to pay stamp duties, then such stamp duties are returned to the people when they want to refer to the court. When it comes to success stories of judicial mediation, it depends on the attitude, on the quality, on knowledge, on understanding that such processes can be more fruitful compared to the cases heard at the court. As we heard from our first speaker, Rimantas was saying that judicial mediation is no longer innovation in Lithuania. In 2005, it was applied in one of the courts of Vilnius district, and now it's accessible by everyone resident of Lithuania. So mediation is becoming a more and more usual way to resolve the disputes, and it's really beneficial to the parties that restored their relationships, that saved their time and money, Initially, it also includes the recognition among the lawyers. At first, they were very skeptical about this particular process, but now they really understand and realize that judicial mediation really helps the interests of the parties, and when it comes to the resolution of the dispute, it's a very good way to resolve the dispute. When it comes to the decision, it also allows people to make decisions. Such settlements are better when they are made in good faith rather than by the judgments of the court. When it comes to the history of judicial mediation in Lithuania, I have to note that it started in 2005 when the Council of Judges adopted the project on mediation, and the very first rules of mediation were drafted by the working group of mediators who were responsible for coordination and evaluation of results. Also, the National Court Administration was assigned to draft the methodology for drafting the law. And then the project was implemented in the Second Court of Vilnius. In 2007, on the 26th of January, the project was prolonged and it was extended, it was expanded. The project of judicial mediation was expanded to the 3rd District Court of Vilnius, to Kaišiadorys, to other institutions which were ready to apply the judicial mediation. Since 2014, judicial mediation has been applied in all courts of Lithuania. Well, when we want to see the historical road, the background of judicial mediation, I want to share some statistical data with you. Of course, it's publicly available, but still I want you to note this huge breakthrough of judicial mediation in terms of how it is used and applied in the courts. When we see that in 2010, we can see that the website publishes information that only 6 civil cases were referred to judicial mediation, 21 civil cases in 2011, 17 cases were referred to mediation in 2012, and as many as 37 cases in 2013. We can also see that the mediation has been increasingly becoming popular, but this pace is not as fast as we would like it to be. We want people to be more aware of this alternative way of dispute resolution, and I believe the main reasons for this is the making society awareness, also the lawyers wish to have proceedings heard before the court, and the judges were willing to hear cases at the court rather than referring to the mediator. These were very, very first, although important steps in the field of mediation, but still maybe this was caused by the lack of the skills of mediation, inadequate training or inadequate preparation to hear such disputes, and maybe this was simply too early to refer the cases to mediation. When it comes to the laws that regulate judicial mediation, I want to note that in 2014 we saw many changes in that field. We saw that we wanted the judges to recommend mediation to people more and more often, to sit at the table of negotiations, to reach agreements, and to find mutual decisions. And later on, legal acts were adopted. The law was adopted that were regulating judicial mediation. So the year of 2014 is very significant in this particular field. We can see that there were 53 cases when judicial mediation was applied, and there were 12 processes when amicable agreements were reached. Maybe the number is not as high, but we can see the prominent trend that despite a failure to reach an agreement, the parties still return to the judge and they submit the agreement, including all conditions that were discussed during the process of mediation. This was also the year when the mediators were paid attention, were focused on, and we cooperated with Norway, who helped their judges, who trained judges, and who shared their good practices and experiences. A lot of employees of the National Courts Administration went to Norway and shared knowledge and experience in how to encourage the employees who are involved in judicial mediation. It takes a lot of knowledge to be provided to the judge for the judges to become good mediators. They have to be trusted by people. And of course, when the process is finished, it's not always mediation that is accountable for one or another resolution of the dispute. Sometimes people do not finalize the agreement, but then they do that in conciliatory agreements. And then in the year of 2015, we can see that the numbers are higher. We see 123 cases referred to the mediation processes. In 2016, we can see that there's the very first convention of the mediators that was organized. So that was a very significant event in this particular field. And the year of 2017, as was mentioned by Mr. Simaitis, it was the year of breakthrough in judicial mediation, which is also confirmed by the numbers. We see that as many as 540 civil disputes were referred to judicial mediation, and in 230 the conciliation agreements were signed. We can see that the cooperation among the mediators is very active. We can see that there were many conferences, many meetings, conventions among the mediators organized, and a lot of discussions took place, as well as many topics were discussed. Then we had mediation promotion measures implemented. We also disseminated information and organized training courses for mediators. I know I'm running out of time, but I still want to mention several aspects of the history of mediation. I could speak non-stop about it, but I want to draw your attention to people, to mediators who create those success stories, who contribute to success of mediation. We had 98 mediators at first, and when it comes to success stories, I want to quote one of the mediators about the evaluation. We can see high qualification of the mediator, preparation for the case, good management of the situation, negotiation skills, psychological skills, and human qualities, human traits which are expressed in an excellent way. This was the evaluation of one of our mediators after the mediation process. Can you hear me? Yes, we can hear you well. So these skills also involve lifting of the stress and letting people talk and reaching an agreement. So such mediators would be very prospective because the caseload of the courts would be lifted, the parties would be happy, would reach agreements, and the mediators were wished success. And the assessments also involved the quote that they are impeccable in their work, and this only showed that these qualities should be possessed by all mediators to make them be trusted by people.
So, what kind of psychological characteristic a mediator needs to have in order to be able to understand the parties? And of course, this is something that is developed in every consistent work. But mediator who has very high qualification, a lot of practical knowledge. The mediator has to be in love with his work. That's why, being sincerely, I can say that not every person can be a mediator. And to conclude my presentation, I would like to answer the question that whether this story is a question mark or explanation mark. I am the member of the Commission for Judicial Mediation, and I trusted the ability of people to settle their disputes themselves. And seeing the situation today in Lithuania, I would say that there must be several explanation marks after the words judicial mediation, because working like this will be creating more success stories in Lithuania about the judicial mediation. And I wish you to have interesting conference. Thank you very much for this exciting presentation, and it's absolutely clear that you are in love with your profession. My little question is, would you say that the work of the judges became a little bit easier for judges with the introduction of mediation, especially in family cases? I would like to ask you, as a judge, has there been any easement for your work as a judge, especially when this judicial mediation was introduced? Yes, it became easier to work because there is the number of family cases decreased, and we can see that mediation is really helpful to people because they are easier, they find their settlement agreement easier. Of course, we would like to be able to ask more questions, but maybe we'll have some time further down the line in the conference. And now we are moving to the Netherlands. That is our first speaker from a foreign country. That is a professional that is highly in love with mediation, an ardent advocate of mediation. We met him several years ago when we understood that the Netherlands are investing substantial resources in development of this institution.
Director of the Netherlands Business Academy, chairman of the Dutch Register of Mediators, certified mediator to the courts, and as I well remember, just a big fan of mediation. So we are very happy to have you here on board on our online conference, and we'll be glad to hear if you have a success in Netherlands with mediation, and what was the efforts, the price of that success?
Yes, hello. Can you understand me well?
Yes, very well, thank you.
I will try to share the screen. Wait. Yes, is the screen clear?
Yeah, we can see it, thank you.
You can see it, very good. Okay. Well, it's always difficult to say what is a success, of course. One thing is for sure, we are all very enthusiastic, very happy with mediation. And I've been in some other countries to see about mediation. I've been in some conferences. And if I look at it, I think in Holland we do not do that bad. So we made 10 golden rules to see how did we make it work, at least to the extent that we have at this moment. So let me first introduce myself, although you already did. So I'm the chairman of the board of the registers. I've been a mediator since 2002. Actually, at first I started just the education, but I got so excited about it that I also do a lot of mediations. Until now, about 1,500, something like that. I'm director of Netherlands Business Academy. And I think this is also maybe interesting for a lot of people. We now have the executive master in mediation, and we are going to bring it with 25 universities all over Europe, and especially also Eastern Europe. And to support this, the EU gave us a lot of money to implement it, at least in Ukraine, Georgia, and Azerbaijan. So, first, why the Netherlands? Why would it be interesting to listen to a story about such a small country? What are, in my opinion, the 10 golden rules to make it work? And all over, you asked about the costs. I will tell something about the costs. This is the number of mediators in Holland. It's a little outdated, 2015, but actually the number is about still the same. So you see, we really started somewhere around 1995, and it got up quite quickly, up to almost 5,000. In 2012, you see a dramatic drop in mediators. It looks dramatic, but actually it was quite good, because in 2012, we introduced a complete new quality system. I will tell a little bit more about it later. And this was necessary to get the status we needed in mediation. And since then, the number of mediators about stabilized. But the good thing is that in 2012, most people did mediation as a side business, and now almost all mediators do it full time. About the numbers, we have about 200,000 official mediations a year, that is court mediations or connected to the courts. But we have a multiple number of informal mediations within the companies, within other places, and this is about 1 million, 1.5 million, something like that. So what did we do to make this happen? First of all, the most important rule, in my opinion, unite. Make sure that you act as one. Not lawyers, psychologists, accountants, whoever, all different groups. No, we are all mediators. So this gives transparency in the market. And we have the strength of numbers. In this way, we have about 3,000 mediators. If you divide it, you're lost. And for us, it's very important to show that we are, first of all, mediator. So the common values as a mediator are much more important than the differences in background. How did we do this? How did we incorporate this? We started the Mediation Federation in the Netherlands, and all important groups have a seat in the board of the federation. There was only one official demand for it, you need to have at least 100 mediators and you must exist for more than 3 years. But we are now even going to skip that to get even more groups into the federation. Rule number 2. Only 2% of all mediation come from the courts. For us, the law is not important at all. I think if you look at all the countries, especially in Western Europe, we have the weakest, the poorest law. We only use court mediations for credibility. I will go into that a little later. And for sure, no mandatory mediations. That's killing for mediation. The only thing we did is encouragement. So we gave people 50% discount if they would go to mediation for the first 2 or 3 hours. That was the only thing we did to get people to mediations. So if you look at the law, there's no connection at all at this moment between the Mediation Federation and the law, although now the government is going to officially make our register the official register in the Netherlands. So creating a clear structure is key. Why? Energy flows where attention goes. So we have a bureau with 10 people who are full-time working on mediation and trying to get mediation work. And within all the courts, there are special bureaus for mediation. And within a lot of companies and governmental organizations, there are bureaus for mediation. So you need clear structures to support it, to promote it. As I said, 2012, we had a dramatic drop in mediators, and this was all because we went to a much higher quality system. We must show that we have at least the same level in mediation as lawyers, psychologists, accountants, and many others. So it's not that we believe that the mediators do not have that level, but normally in most countries, they have the level because they are lawyers or whatever. So we decided also on mediation, you must have at least that level. So we are mediators, not a side business, so take it serious. How did we do this? The federation is only for the policy, but we have the register, which is purely based for the quality assurance. It has a special board and it has about 90 people working on the quality system. First of all, towards the mediators. We accredit them and we audit them. And if you look at what we do for them, of course, we have the basic acceptance, the basic education, written exams, assessments. There's a whole quality system around it, disciplinary board, complaints board, etc. Just the same as for lawyers or accountants. And we do a lot of permanent education for the mediators. Every mediator is audited every 3 years and has to show that he's doing enough mediations and doing all which is necessary for the permanent education. The same goes for the educational institutes. And this is something where there's a lot of change at the moment. So the basic to become a mediator is that you need to have at least bachelor or master basics. And now, and I think this is the same in almost all the countries, you follow a basic training in mediation, which is about 23 blocks of 3 hours. I've seen some differences in the countries, but mostly it's something like this. Then you do your exam, maybe an assessment, and then you can register. This costs about 7,000 euros altogether, talking about costs. You can do some specializations, family, labor, whatever. costs you another 4,500 euros. And we have about 32 accredited institutes who can do this. We check them every 5 years. They have to pay a basic admission and contribution. So as a federation, they have to pay us about 119,000 euros a year. But take it seriously. So what is the change? A basic education of 23 blocks of 3 hours. Is this enough to make a real profession? We believe it's not. So if we believe that mediation is a separate profession, we have to change something. And this change is now going on. So what is the big game changer? We start with bachelor mediations and master mediation as a full education with the regular universities. That means that the whole world is shaken up. At this moment, mediators are in average above 55 years old. And now all of a sudden we will have 22, 23-year-old kids doing mediations. For most mediators, this is difficult to accept. Is this possible? Do they have enough life experience? Well, at first, everybody said no. Now everybody sees that this is bullshit. We have lawyers of 22 years old. We have psychologists 22 years old. So why not mediators of this age? Another big game changer is that in this way, it is financed by the Ministry of Education. And that makes it much more cheap. And it will be the end of the traditional private institutes that have to charge much more. Rule number 6, if you cannot beat them, join them. What we see is that in most countries, the biggest problem is how to make lawyers positive towards mediation. So we believe that the judges and the lawyers are our friends. They are the ambassadors. And the second, win the crowd because they are our clients. As we said, the court mediations are only 2% of all the mediations. That means that the normal public, the normal people in the country, they will have to go to mediation. The companies will have to go to mediation. And it's not the court or not the government forcing it. So win the judges, train the judges, and make them say, okay, people, before you go to court, go to mediation. That means to us, yes, people in the register have the exclusive right for all court mediations. In every court, we have a special bureau for mediation. It helps, it's good for credibility. Judges send people to mediation even during the cases, but it's only 2%. So much more important is, how do you find the entry doors to the market? Where do we find conflicts? Who has something to lose in a conflict? Where can they win something by mediation? And that means that you have to go for prevention rather than when there's already a big conflict going on. And I think this is the big change. And that means that mediators try to find entry doors to governmental organizations. All big ministries have their own department of mediation. The public sector entities, the railroads have their own mediators, etc. Private organizations, insurance companies, multinationals, all have their own mediation bureau. And of course, everyone who is handling conflicts in some way. The normal fee for a mediator is somewhere between 140 to 350 euros per hour. And that means that we can compete with any other profession on this. How do we get people like mediation? That's also simple. Train them all. I was a stupid accountant, not knowing even what mediation was, until I did the course, and then I got enthusiastic. So train them, judges and lawyers, mayors, politicians, HR managers, CEOs, accountants, advisors, insurance companies. We trained all of them. At this moment, I think there are about maybe 150,000 people trained in total. And this gives a lot of credibility in the country in all organizations. And in my opinion, this is used too often. Many countries say, with us, it will not work. Our culture is not open for it. I do not believe this. I think Holland has a quite good court system and people believe in it. So in all the other countries, people do not have more faith in the court system, maybe even less. Conflicts are similar all over, and people want to have control in finding solutions, and they don't want to lose. So, in my opinion, these are the 10 golden rules to make it work. It was short, but if you like to know more, you know where to find me, and I can share, and I'm really happy if other people would share their experiences. Thank you very much.
Thank you. Thank you also, Professor. It was really very informative and rather clear plan what to do in other countries in order to make mediation successful. I've got a small question to you because it looks like mediation not just a separate profession in Holland, but it looks like a separate business in your country. So if you're so much against mandatory mediation, if you say that courts shouldn't make too much mediation, court mediation, what are these tools, incentives for people, for the crowd to come and try mediation?
Well, I think it's very important that people believe in the concept of mediation. So if people believe that it will give a better solution, it will cost less, it will be better for them, then they will come to mediation. If you make it mandatory, I think Italy, Greece are good examples of it, then people see it as an obligation, and people don't like obligations. So it works the other way around. And this means that we put a lot of effort in promotion. From the courts, we said, okay, you can have a discount, which makes it more cheap, but still you are free to do it. We believe in it. The judges say we believe in it, so it might help you. And otherwise, you never know what I will decide. And in that case, people will go there. But that means that both the lawyers and the judges must be positive. So this is always the first step. Make lawyers, make judges positive towards mediation. That's much more important than make it mandatory.
I see. Thank you. Thank you so much for your answer. I would say that at the moment we can say goodbye to you, Professor, but we surely hope to meet each other again in other conferences and other mediation projects. Thank you so much.
Thank you very much. Bye-bye.
Tai tęsime mūsų konferencijos darbą ir kviečiame kitą pranešėją, Lietuvos atstovę, profesorę daktarę Agnę Tvaronavičienę, Iš tikrųjų, tema profesorės yra labai kontroversiška. Daug buvo diskusijų rengiant mediacijos projektą.
Presentation is quite controversial. She's going to speak about mandatory mediation. The question is mandatory mediation at all compatible with the idea of mediation? The professor is also the accredited mediator in London Efficient Mediation Center, also chairman of the arbitration course.
Labadiena, moderatoriai, labadiena, klausytojai. Tikrai džiaugiuosi būdama čia ir
good day to the moderators and the audience. I'm really happy to be here and to speak about mandatory mediation, which is a very important topic in Lithuania. I will be speaking about this model in Lithuania because it's different from those in other countries, and I'll be speaking about challenges. What challenges are we facing and what do we have to do in order to achieve success in mandatory mediation? Many spoke about the advantages of mediation. Mediation allows saving time and funds, allows the parties to maintain their friend relations, but we were speaking about mandatory application. What is that? It looks quite simple, quite understandable, because it's cheaper. It is the measure that can settle even the most important judicial problems. But still, I would like to ask, is it really easy to code the success story? Because I'm sure that we have audience from foreign countries. I would like to introduce certain legislative provisions in Lithuania. What kind of regulation is in this area in the country? Is the mandatory judicial mediation is allowed according to the civil code, according to which the judges have a right to transfer the dispute to mandatory judicial mediation. Also, that the mediation can be used in concerning certain categories, like family disputes have to be decided in extrajudicial mediation procedure. Speaking about mandatory judicial mediation should be tackled in more detail because data is really scarce. I will be speaking more about the aspects, mandatory aspects. The statistical data shows that starting from 2019, when the judges were allowed to channel the parties to mediation procedure, we don't have a lot of statistics, and we have to say that this right is not really being taken advantage on any larger scale. So the question, why is this mandatory mediation not being used, and how can we use this potential more efficiently? Another challenge requires some contribution from the part of the science. Since the judges have to decide whether to transfer this dispute to mediation, we have lack of criteria on the basis of which the judges could decide which of the cases can be transferred to mediation. And I would like to say that sometimes we need to correct certain maybe errors from this mandatory mediation when the parties only realize their right to take advantage of mandatory mediation.
When it comes to the scheme of mandatory pretrial mediation, we should start with the fact that parties to the dispute must apply to the service and they must choose the service. And if they want to use the service free of charge, they can choose a mediator from the list. The parties can apply jointly, or if they disagree, they can apply to that service individually. If they apply jointly, then the state-guaranteed legal aid service makes a decision and refers the documents to a mediator, who then contacts the parties and carries out the mediation process. In other case, the parties can apply to the service and find the opinion on the mediation. Then the second party is sent a note, and then it must give a response. And then, in case of acceptance, the mediator is appointed, and the mediation process can be started. In case of a refusal or failure to receive a response, then the mediator can exercise the duty to carry out the mandatory mediation. When we pay attention to the European countries or the practice of other countries, I can state that our mediation is a very moderate process, because the single aspect that is mandatory is the obligation to organize it, to initiate it, because the parties can refuse to undergo the mediation process at any stage of the process. Well, mandatory pretrial mediation. Let's look at the statistical data. Well, the data is for September of 2010. So we can see that in total over 4,000 requests were received, and only 165 of the requests were joint, that is submitted by both parties, and almost 5,000 requests were submitted by one of the parties. When it comes to the mediators, we don't have any data because mediation is a confidential process. There's no register as such, and this is one of the additional challenges as to how we should tackle it. And the most important thing in this particular field is that an appointed mediator, let's say the case reaches the mediator, the appointed mediator, there were only 2,077 cases when the mediator was appointed. In other cases, the parties did not meet the mediator because the other party to the dispute sent a refusal to take part in the mediation process, or the response was not received at all. So let's analyze the other figures. How did we manage at mediation when the mediator was appointed? So there were 46% of the disputes when the amicable settlement was reached. So maybe the first years were really difficult in terms of the experience, of qualification, of the attitude of the parties to mediation. So this number comes with no surprise, but still I can see it as very successful in the context of the global trends. Mandatory mediation is always balancing within the range of 50%. So our results quite fit this range, this global range. And now let's move to the challenges of the mandatory pre-trial mediation, because I want to share them with you. And the very first challenge would be the numbers that I've showed you. The major part of all cases that could be referred to the mediators do not reach them, unfortunately. So when we think of the future, we should increase the number of cases that are referred to the mediators. The mediators are appointed only in 42% of the cases, and the rest of the cases, well, yes, they are subject to mandatory mediation, but the state-guaranteed legal aid service then submits the document which certifies that the party applied for mediation, and that party, of course, fulfills the obligation. And then the door to the court is opened, because the opportunity to employ mediation was used. So the cases when the parties fail to give a response is also very important. We can speculate whether it was subject to a wrong address or something else, but still the situation is as it is today, and it would be unreasonable to reason why and how the problems should be solved. But I believe that we should increase the attractiveness of mediation to our users. If we see mediation as a service, as the colleague from the Netherlands was saying, then maybe mediation would be more popular. And if we speak of communication as very formal, carried out in a written form only from the very beginning of communication, without including any benefits of mediation, then I believe the mediation will not be chosen by many people. So I invite you to discuss how we could make mediation more attractive to the people, including all mediators, as to what we could do in this particular field. And then, when it comes, let's say, to a liberal model of mediation, maybe it's time to do that, and I can see there's space for it, and maybe we should set an obligation for both parties of the dispute to participate in the first meeting of mediation, so that they meet a mediator, and then the mediator would be able to give a motivational speech to both parties, and maybe then, when parties see they will lose nothing and they will see a sincere wish from the mediator to help them, maybe then again mediation will become more attractive and more popular. There's one more problem. We are failing to ensure the one box principle. Again, if we see mediation as a service, there would be several problematic aspects in this. And we should discuss the requests which are considered as not submitted. And this happens because the parties do not clarify their contact details. Maybe they did not have any contact for a very long time, and they do not have they do not know the contact details of the other party. So maybe the situation could be very simple to be resolved. The other aspect is drafting the conciliation agreements and requests for the courts, because people have different expectations, different views of how mediation works. And again, access of the mediators to the registers, it should be solved. And a new aspect that was raised in July of this year, when the adoptions when the amendments of the state-guaranteed legal aid were adopted, which resulted in the legal acts related to divorce and so on. So this aspect is the ratio between mandatory mediation.
Kad privaloma mediacija atitiks geriausias natas tradicijas, nebus labai biurokratiška, nekainuos jam daug papildomai.
And also we should shorten the duration for appointing the mediator. Again, if we only observe the process of submitting the documents, it's very often the case that it takes 1.5 months from appointing the mediator, which is significant for the parties, for the families, if they have many disagreements. So we should look for an antidote for it. Maybe this period should be shorter. Or we should look for other screening methods which should be more expedient, and maybe they should submit their agreement to mediate faster as well. And to sum up, I want to raise one more question. We shouldn't forget that we feel this great necessity to increase the number of hours of mandatory mediation as well as the hourly rates of the mediators. So, for the information purposes, they have 1 hour for preparation for mediator, 4 hours for the whole process of mediation, and 1 hour for finalizing the process. Results and the hourly rate is 16 euros, including VAT. So very often the costs for fuel are not compensated. Also, the interpreting services are left aside. This question is not solved as well. So to reach our goals, to make the parties more satisfied, we have to discuss all opportunities to have focus on it more. We have to discuss the number of hours and discuss the hourly rates. And everything begins with people. We shouldn't forget people. If the mediation services are provided by people who believe in this service, if the service is administered by people who believe in it, who believe it's meaningful, then the results will be great. So we should develop the cooperation between mediation management institutions and mediators, because when it comes to formalities, they take time, they take money, the procedures must be repeated, everyone becomes tired, including mediators and the parties to the dispute. And there are, of course, mediators who provide services in certain institutions, but the disappointment is felt. They very often refuse to provide such services. So we should improve the mediation services and we should focus on it more. And here I can see that a huge role could be played by the Chamber of Mediators. Mandatory mediation really provides an opportunity to find an amicable settlement, to restore the relationships between the parties and to foster different culture of dispute resolution. Many people have already tried mediation and many people really have their success stories, because more than 147 families and their success stories show that mandatory mediation as a source of accessible amicable dispute resolution really helps to tackle the challenges. And the proverb says that everyone comes to the source of wisdom with their vessel. And to make this spring endless, to make it sufficient for all kinds of
Tai
vessels.
tegul privalomosios mediacijos versmė būna neišsenkanti, o jos
Let's make
užtenka
mandatory
įvairaus
mediation
dydžio indams
more attractive and
Ačiū Jums labai.
used by more people, as more people as possible. And thank you very much. And now I'm ready to answer all your questions if there are any.
Thank you to our speaker. Regretfully, we don't have any questions concerning this presentation, but I was specifically interested in how this mediation is operating. But I can see that it's really a success story, that about 46% of the disputes were resolved by settlement agreements. So that is a very good indicator, and it's not really much different from the indicators from other countries in which mediation is much better developed. So we have to look at the situation and to see what can be improved, and we have heard very important insights on what can be, where are the areas for improvement. Is we need to believe in mediation as a means of resolving disputes. To be able to work for 16 euros per hour and then pay the taxes from that amount. So we need to recognize that in order to foster that belief, we need to promote somehow, encourage financially, but the time will come. So I'm really happy that despite all the challenges, I'm still happy to see this positive approach towards mediation and development of understanding and awareness that is a good thing. Whether we take advantage of that, whether we use it, that depends on each of us personally. Thank you very much for the presentation. Also, responding to the messages that we receive on YouTube, you can see that both the audio recording of this presentation and also the slides will be posted on internet. We have approached another quite pleased moment, that is a little break for a cup of coffee. So everybody is invited back to come to after the break at 10:15.
Sveiki sugrįžę po pertraukos į mūsų tarptautinę konferenciją. Pertrauka visada.
The break to our international conference. As usual, the break was really, we didn't finish so fast. Now we have to...
We are glad to see your smiling faces.
It's
very nice to say that Lithuanian National Court Administration is always cooperating with Norwegian court administration, and we always take the best experience from Norway. So today we are also searching for a new maybe recipes how to make this mediation successful. And that's why we'll be happy to listen to your presentation, Success Story and Cost of Mediation in Norway. And I would like to introduce our presenters. These are appeal judges at the Gulating Appeal Court from Norway. And if I make any mistake, please excuse me, Mr. Kai Ove Roset and Mrs. Groberger.
Yes, hello.
Hello. So the floor is yours.
Thank you so much. Good morning, ladies and gentlemen and colleagues. We are calling you from Bergen in Norway, and thank you so much for this invitation to the Digital Conference on Mediation in Lithuania. We are going to give a presentation of the success and costs of mediation in Norway. As you mentioned, my name is Gro Berge, and I'm here with my colleague Kai Ove Roset. We are both working as appellate judges in Gulating Court of Appeal. I'm going to share the screen with you now and our PowerPoint presentation. Just a moment, please. So, Gulating Court of Appeal is situated in Bergen, the second largest city in Norway. And just to give you a brief picture of our court system, there are 6 courts of appeal in Norway, 63 district courts, and 1 Supreme Court. Both Mr. Roset and I have worked as appellate judges for about 6 years, and we are part of the mediation group in our Court of Appeal. Previously, we have experience as lawyers working within business law. And during our work experience, we have participated in mediations, also as legal representatives of the parties. Historically, mediation has very strong roots in Norway. Already in 1795, local conciliation boards were introduced in minor civil cases. The boards consist of lay members, not educated lawyers. The system still plays a significant role in the Norwegian legal system. The law requires each municipality to have a conciliation board, and mediation before such a board is mandatory for all civil cases before legal proceedings can begin. There are some exceptions to this rule. In example, if the claim exceeds 24,000 euros and both parties are assisted by legal representatives, then the case may be brought directly before the court. Around the 70s, the ADR movement, the Alternative Dispute Resolution movement, emerged in the US. And the new ideas on communication and conflict resolution were transported to Norway around 1990. This led to a pilot project whereby court-connected mediation was introduced in some district courts and 1 court of appeal. The project later expanded, and from 2006, all Norwegian courts have participated in the project. Today, every district court and court of appeal in Norway offer court-connected mediation. Mediation was first legally regulated in 2008, and today the Norwegian landscape of mediation is complex. Norwegian law operates with different types of mediation, both private and court-connected mediation. Many publicly funded institutions offer private mediation, but in Norway, court-connected mediation is much more common and popular than private mediation. It's important to emphasize that court-connected mediation is only offered in civil cases, and criminal cases can never be settled in this manner. There are two types of court-connected mediation in Norway: judicial settlement efforts and judicial mediation. Judicial settlement efforts is the general obligation of the court to consider the possibility of a settlement between the parties on each stage of the case. A settlement may be reached through direct contact with the parties, during a preliminary hearing, or at the latest during the trial. During these efforts, the court cannot hold separate meetings with each party, offer advice, or present proposal for a solution. It's important to keep the judge impartial, because if the parties do not reach a settlement, the same judge will hear and decide the case. Judicial mediation is a more formal approach by the court to settle the dispute between the parties. Both the courts and the parties may initiate judicial mediation, but in general, the court cannot mediate against the will of the parties. If the parties accept to participate, a mediator will assist the parties and their legal representatives in reaching a settlement. A preparatory judge usually conducts the judicial mediation. If the parties do not reach a settlement, the case is assigned to a different judge and the case continues in the litigation track. Some courts, like Gulating Court of Appeal, offer educated and trained judges to conduct all judicial mediations. There are 32 judges working in Gulating Court of Appeal, and a group of 3 judges are dedicated mediators, in addition to perform their ordinary judicial duties. It's also possible to use others as mediators, in example, trained lawyers, but this rarely happens in Norway. In our experience, the parties want a judge to act as mediator. So, in the further, the scope of the presentation will be limited to judicial mediation. And during the 3 latest years, from 2017 to 2019, Norwegian district courts mediated approximately 23% of all civil cases. 66% of all judicial mediations ended with a settlement between the parties and no trial. During the same period, Norwegian courts of appeal mediated 14% of all civil cases, whereby 87% ended successfully with a settlement. In our experience, mediation leads to decreased number of cases, money saved, and more results that are satisfactory for the parties involved. And we will point out the key factors to the success of mediation in Norway. First, culture plays an important part. Norwegian culture is described as pragmatic and conflict adverse. Self-determination and equality are also important values for Norwegian people. A settlement and a practical solution will therefore often be preferred over a trial and a more principled solution.
Thank you, Gro. Before I start on the remaining part of our presentation, let me inform you that within the time frame we have been given, it will only be possible to give a short and general comments to each of the bullet points that follows on this slide. Well, the second key factor we would like to highlight is the Norwegian legal framework on mediation provides vast flexibility for the mediator and the parties on how to conduct mediation. The legal framework also provides alternatives on how to structure a settlement achieved in the mediation track. Okay. The background for this is that our legal framework is based on the acknowledgement that strict requirements or procedures will not be limited to the possibility to adapt the negotiations to the fact that emerges from the discussion. It will also limit the possibility for the mediation to end with a settlement. We will come back to the flexibility in the last bullet point under this section of our presentation. The third key factor is to ensure sufficient knowledge and skills in mediation for the mediators and the lawyers. Mediation is often a complex process, and we have acknowledged that a successful mediation depends on the mediator's ability to negotiate and find a basis for settlement. The Norwegian Courts Administration has therefore implemented mediation as part of the mandatory introduction course for all new judges. Furthermore, the NCA offers special seminar courses on mediation for judges who want to improve their knowledge and skills as mediator. For the lawyers, who of course plays an important role in the judicial mediation as legal representatives of the parties, training and knowledge about negotiation and conflict solving is a part of the Norwegian Bar Association's mandatory course to qualify for the license required to practice as a lawyer. The fourth key factor, impartiality and confidentiality, are considered to be crucial because the parties must be confident that they can pursue the mediation track without jeopardizing their position in the legal proceedings should the mediation fail. We have therefore implemented rules stating that the judge acting as a mediator shall not participate in the later legal proceedings should the mediation fail unless the parties agree and the judge considers such later involvement in the case imprudent. Furthermore, by making the mediation meetings confidential, both the parties, the mediator and the lawyers are obliged to keep information provided during the negotiations confidential. As a result of this, the parties cannot, in the later legal proceedings, give any statements about the facts given in the mediation meeting. The fifth factor, which we assume has an impact on the success of mediation, are the time-saving and cost-reducing effect the mediation track may have for the parties. Even though we have a fairly speedy litigation process in Norway with an average processing time of 5.2 months in 2019 for the district courts and 7 months for the appeal courts, the processing time and not at least the litigation costs involved, especially if the case also must be litigated for the appeal court, is clearly factors that motivate the parties to try the mediation track. Let me then return to the key factor mentioned earlier, the vast flexibility provided in our legal framework on judicial mediation. First of all, we have few formal requirements on how to conduct a mediation meeting. The procedures of the meeting is determined in consultation with the parties on a case-to-case basis. the legal framework also allows the mediator to have separate meetings with the parties during the mediation meeting. The most used procedure is to start and end a mediation meeting with a joint session and to have such separate meetings with the parties. The possibility to have separate meetings is, in our opinion, most likely the main reason why judicial mediation is a success in Norway. Secondly, the legal framework allows the mediator to use different kinds of mediation techniques. Hence, the mediator may take both a facilitative and evaluative approach in exploring the basis for settlement agreement. And just a moment, I'm trying to fix the screen. Okay, hopefully we are back. I think we have to continue just to end the presentation. Okay. Secondly, the legal framework allows the mediator to use different kinds of mediation, just to repeat it. Hence, the mediator may take both a facilitative and evaluative approach in exploring the basis for a settlement agreement. Thirdly, if the parties reach an agreement, they may choose to structure the agreement either as an in-court or an out-of-court settlement. The structure does not have any impact on the parties' obligation to honor or adhere to the agreement, and the result will, regardless of the structure, be that the legal dispute is brought to an end if there are not any pending issues for litigation. In-court settlements means that the entire agreement is recorded in the court record of the proceedings. The agreement will therefore become a part of the official court documents available to the general public unless the case itself by law is considered confidential. Should this be a problem, we may use out-of-court settlements, which means that the agreement itself only is referred to in the court record of the proceedings. The content of the agreement will therefore not be a part of the official court document. Yes, the last topic is the cost of judicial mediation. We should say that it has not been an easy task to gather information about the cost, and we assume that the information is not accurate nor complete. We will therefore present some figures from our own court to illustrate cost and cost savings for the court. During the period from 2017 to 2019, we have allocated 1 man-year to mediation. Based on the stipulated labor cost for alternative legal proceedings in all the cases that have been in the mediation track, the 1 man-year has given our court an operational saving of 3.3 man-years in 2019, 2.7 man-years in 2018, and 4.7 man-years in 2017. This illustrates that mediation may have a remarkable cost-saving effect for the courts. For the parties, mediation is clearly a cost-saving way to end a legal dispute. But should the effort on reaching a settlement fail, most parties will probably consider both the preparation for and the time spent in the process as unnecessary cost-consuming. Well, we have then come to the end of our short presentation, and we thank you all for your attention.
Also very much for sharing your all experience. And finally, we have a question from the auditory to you. So our people are asking, what is about the culture of Norwegian people? Do they go to the court if they have a dispute, or they first think about peaceful dispute resolution?
Yes, as we mentioned in the beginning of the presentation, the culture is in Norway is that we are pragmatic and try to solve things in between us. So I think the answer to the question would be that we are not conflict orientated, and that may also be the reason why the conciliation boards in the municipalities around in the country often solves most of the disputes between, especially normal or ordinary people.
Yeah, thank you very much for the answer. And one more question, because after your presentation, the questions started to pop up immediately. If Norwegian state compensates any expenditure on mediation for the parties?
It depends on the case. Some cases are supported with fundings based on a separate regulation, and if so, the judicial mediation track is also compensated. The legal cost will be compensated. So that's in the same way as in the legal track, litigation track.
I see. One more question would be from my side, because it's a very hot topic for our judges, mediators. How do you see the workload of a judge? Because you have ordinary cases and cases of mediation. Is it okay to combine them, or it's different opinion of yours that it should be a certain amount of mediation cases and not more, and the others should be ordinary classic cases?
I think that's a very good question.
Yeah.
And we discussed that, and we tried different to do
models.
Sorry?
Different models.
Yeah, we tried different models because we both find it's quite hard to perform our ordinary duties as judge and to focus on the mediation. I don't know if you want to say anything further to that.
I think the way to do it, it's the best way to do it is the model we have now, where we split the work on 3 judges in the total of 1 man-year per year, and that we have separate weeks that we are allocated. That is allocated only to mediation. So you can focus on mediation in a couple of weeks at a time.
I see. Thank you so much for your also presentations and all your answers. It was great to hear from you. So best regards, best wishes to Norway judges while implementing mediation. And goodbye to you. Of course, you're welcome to listen to our conference and participate further on. And we move to our neighbor country, Belarus, and have another very interesting presentation. I'm sure it will be interesting despite all political nuances. We have on board Mrs. Tatiana Belaeva. She's a very renowned mediator, not only in Belarus, but also worldwide. She's a regional mediator for the compliance advisor, ombudsman of the World Bank Group, a mediator of the Global Mediation Panel for the Office of Ombudsman for United Nations Funds and Programs, serves as a mediator on the panel of mediators at the Supreme Court of the Republic of Belarus and on the panel of neutrals at the London Court of International Arbitration. So, Tatiana, you are very, very much experienced mediator, and I know that also like a big fan of mediation. So we are very glad to hear your presentation about Belarus success story.
Thank you so much. I'm really happy to be here, and I'm sending my warm greetings from Minsk to our neighbors. Yes, today I would like to talk about success story of mediation in Belarus, and of course, I would give a little disclaimer that mediators in Belarus, we don't believe that we have a complete success story, and we believe that we are just moving successfully on the path of mediation development. And I would like to share our experience and what was this path to us in Belarus. We started in 2010, but until 2014, we didn't have like any law in mediation, and we have a couple of provisions in economic civil procedural codes, but they did not work. They were just like a nominal provisions. So we started with pilot projects in Belarus, and they lasted for about 3 years before our Supreme Court decided that mediation can be adapted to our reality and can be successful in Belarus. So I would like to share a couple of slides and PowerPoint presentation with regards to that, and also I have a couple of figures that might be informative for you. So just let me share my presentation. Okay, I think now you can see it on your screens. So like I said, we have first a couple of pilots before we even started to develop law on mediation. The first pilot was in 2011, and we have 2 regional courts that were involved in the pilot. And you see it's quite a small number of cases. It's a little bit over 100 cases that were sent to mediation. That's economic cases, so it's business cases, and we have 52% result. And then we have in 2014 we have a smaller project for 1 court. It was 48 cases, but the cases were the most complex and the ones that lasted for a couple of years. So they were not like really simple cases. And we have again over 50% settlement rate. And these rates, as world practice shows, they show the success of first implemented procedure, mediation, and after these pilots, finally our courts and our legislature decides that mediation can be developed in in Belarus, and that we have ground for that. Before 2014, I need to tell that there were little faith in mediation everywhere, in courts, especially among lawyers, among judges, and among the rest of civil society and business society. So we were very skeptical about that, and it took really a while to overcome this approach, this attitude to mediation. And these first pilot projects, they were pretty important for us to show that mediation can work. So we have another pilot in 2015, but it just proved that mediation can be successful, and we have a higher settlement rate, as you can see. We have a legal framework on mediation, and it's quite developed by now. So the law on mediation came into force in 2014, and it adopts a lot of provision from European Directive on Mediation. So we took after the European law on mediation, we have 8 legal acts as of now on mediation. We have ethical standards of mediator. We have mediation rules, and we have other acts that regulates several aspects of mediation. So it's quite legal framework is quite developed. Now we have over 750 mediators in the register of mediators of the Ministry of Justice. And Ministry of Justice, that's the body that regulates mediation development in Belarus. We also have Qualification Commission on Mediation. That's also in the Ministry of Justice. So it's a like ethical body and body that overlooks the activity of mediators. The application of mediation in Belarus, we have quite a common approach. I think in mediation, corporate conflicts, commercial conflicts, labor conflicts, family conflicts, other civil law conflicts can be resolved. We don't have mediation in criminal and in administrative cases. We did have a couple of attempts to introduce changes in criminal procedural code and introduce restorative justice approach in Belarus, but it was not that welcomed. At the time we tried to introduce, so we still have this draft law, still have these amendments, draft amendments to criminal procedural codes, but now they're not introduced, and I think they are waiting for the better times. I will share a little bit of data on mediation. That's the official numbers that our Ministry of Justice has. I need to tell you that it's not the whole numbers. That's the numbers that 3 our major mediation centers provide. So we have bigger number, but that's the like official number that was provided to the Ministry of Justice. So in 2017, we have 1,359 mediation, about the same number in 2018, including 1,030 with agreements. So you see the settlement rate is pretty high for these cases. In 2019, we have less than 1,000 mediations, but again, if you look at the settlement rate, it's like 648 with agreements. So that's a pretty, I would say that pretty impressive settlement rate for us and for our mentality and for our attitude to mediation. And I would like to share a little bit of a statistic from one of the major mediation centers in Belarus. I'm affiliated with this center, and it shows the dynamic that we have right now in mediation development in Belarus. So it's just like an example of statistic, but basically overall in Belarus we have a similar statistic. So you see the number of cases steadily growing. And with regards to type of cases, in 2015, that's the 1 year after we adopted the law on mediation, we have 39% of commercial disputes, 44% of division of property, and child custody, 17%. So that was like the major disputes, type of disputes. In 2019, you can see these little percentage numbers, but that shows the diversity of cases that started to be resolved in mediation. We have 40% of cases, and that's the family mediation, including property and child custody. 29% that's commercial disputes. So we have growth of family disputes and division of property in divorces cases in mediation in 2019. And if you look at the source of cases, in 2018, 56% of cases were referred by the court, and only 44% that's out of court, when people contacted mediator or mediation center themselves. In 2018, you can see that out of court mediation is 62% already, and court mediation number decreases, it's 38%. that shows that people now in Belarus know what mediation is, what mediator does, and they have more trust in mediation. So that's a pretty good development. With regard to mediation results, if you look at 2015-2016, agreement cases ended with agreement 43%. So again, that's a pretty high number of settlement rate. In 2017 and 2018, 79%. That's actually also a good number, and it's a little bit. There is a little bit of decrease of the number. That's because of the diversity of cases that started to come to mediation. So it's not only commercial and family. Now we have investment disputes. Now we have complex land disputes, and that's a little bit decrease the settlement number, but still it's quite high. With regards to fees in mediation, if you look at 2015-16, that's the beginning of development of mediation. You can see that 42% were paid mediation and 58% free of charge. So we had to start basically with free of charge mediations in order to develop mediation and in order to get familiarized people from this procedure. We faced the reality that and Belarus people, and especially business, they didn't want to pay for the unknown procedure. And in order to introduce the procedure, we took the approach that we provided a lot of free of charge mediation services. And you can see in 2017 and in 2018, the dynamic changes. So now 70% of cases are paid, and 30% of cases are free of charge, and most of them to like social vulnerable categories of civil society. So it's not business cases that are free of charge. Now we have new rules in mediation introduced recently in 2020, and again they're quite, I think they're quite progressive. Now we have enforceability of mediation agreement in courts. So commercial mediation agreements and civil, family, land disputes, labor disputes, they can be enforced in courts if one of the party does not fulfill its obligation under the mediation agreement. Now we can apply mediation at any stage of judicial process, even at collection stage. Also, we have mediation clause introduced, and it means that if any contract has mediation clause, the court cannot accept the claim unless there would be a notification from mediator that the case was in mediation and it was not resolved. So that's a big progress, especially for business mediations, because a mediation clause that's very important and motivates parties, especially in business, to come and see mediator. Also, we have introduced an obligation of the judge to inform the parties about mediation procedure and the right to be referred to informal meeting with the mediator. So that's the compromise between mandatory mediation. We have a huge dispute about mandatory mediation, and that's the compromise. So we don't have mandatory mediation as of now, but people can refer, judges can refer the cases to mediation, and it's mandatory that they need to inform the parties that they have a right to be referred to mediator and to settle the case in mediation. And I have I think 30 seconds left, and just I would just like to mention that Belarus ratified Singapore Convention in 2019, and the convention is now in force. And now we are introducing changes in our law on mediation and in procedural codes with regards to implement the provisions of Singapore Convention. So now we can enforce, hopefully after we introduce the changes, we can enforce international commercial mediation agreements almost the same way, of course, with some special procedures as arbitral awards, foreign arbitral awards. So we are very proud that we did ratify the convention and that we are working on its implementation in our laws. We have a lot of services for mediators that we created just to be known in the country. We have national directory, we have international directory, it's Eurasia. You can check the link if you're interested. We have a lot of international events. We have international Russian language student contest on mediation going on already for 4 years. That's what we do to implement and introduce the benefits of mediation. And our course is, like I said, we have a lot of volunteer work. We had to work for free just to introduce mediation, especially to business. We have tension, as most, I guess, of the countries when they start to introduce mediation with lawyers. We have resistance of courts, of business. We have also misuse of mediation by lawyers. I don't have the time to talk about that, but that's also the reality that we face as of now. But we are very happy that we have this procedure, and I hope that we will develop it further. Thank you for your attention.
Thank you, Tatiana. It was really a great evidence that you are on the successful route, successful path for mediation. We've got a question from the auditory to you. The auditory noticed a slight drop in the number of mediation cases and wonders what was the reason for that.
That was the reason that relate to our commercial cases. As I told you, business are very cautious in Belarus to be involved in mediation. And when we stopped doing promo activities to business, the number of cases dropped, and that relates to business mediations. So unless we always inform the business and try to do some promo activities and events, business events, when we stop doing that, we have a drop of cases for business mediation.
Yeah. Business, let's say, society is always very pragmatic.
Yes. They don't want to pay money for the services that the results are unknown, and mediators cannot guarantee that they will sign mediation agreement. And business people, they don't like that. They would like to have guarantees, and they would like to see for what they pay money.
Yeah, I understand. Well, we also have a question. If Belarusian courts resist mediation, or do they support?
First, they resisted mediation. They did not believe in mediation and felt that that's an obstacle for them because cases can come back from mediation, and the judge had to decide and took over the case and decide it again, and it just prolongs the procedure, and that's it. So first, they were very skeptical about that. And the reason why we introduced these pilot projects in courts, that's because of the judges being very skeptical. So basically, we came to the head of courts and we said, give us the most complex and hardest cases that you don't want to decide, and we will try to settle them, and you will see the results. If you like the results, then please give us the floor in court to introduce mediation. So that was our compromise with judges with pilot projects. After pilot projects, when you see there was a settlement rate more than 50%, the judges gradually started to believe in mediation. And now we have a very common practice when judge calls a mediator that he knows and trusts his skills and asks to take over the case that is too complex or it's better be in mediation than in court proceedings. But it was like a very slowly dynamic. The judges changed.
Yeah, that was a very smart way of proving that mediation can work. Thank you very much, Tatiana, for your also very interesting presentation. So we say goodbye to you at the moment, and we will move. Let's fly to Italy. Very sunny Italy, because yesterday I looked forecast and it is around 27 degrees there. So hello Genova, hello Francesca.
Hello, yes, nice weather outside.
Great.
Anyway.
Yes, so we are very happy to hear the story of Italian success and the cost of it. We don't only talk about financial part, but also the input of people, the ideas. And let me introduce Mrs. Francesca Cuomo-Loa. She's a lawyer and a very experienced mediator, member of the Mediation Board of the Bar Association in Genoa. She's trainer for mediators and lawyers, and also author of various scientific essays on mediation and alternative dispute resolution. So Francesca, as I remember, knows everything about mandatory mediation, pros and cons. So really, we are ready to hear your presentation. Please.
Thank you very much for the invitation to this very interesting conference. I think it's a unique opportunity to learn and compare different models and story of mediation. So I will try to add my part by presenting the story of Italian mediation and, as you said, Italian mandatory mediation. Let me try to share my screen so that I can, okay. Okay, sorry, okay. So, I will begin by giving you the legislative framework, illustrating the rules governing access to mediation and the rules governing the mediation proceedings. Then I will share some information with you about the cost and some figures and statistics, and trying to draw some conclusions about the issue of successfulness and cost of mediation in Italy. So the beginning with the legal framework, mediation in Italy has been introduced in 2010 by the legislative decree number 28 that has been enacted in order to implement the European directive number 52, but also to reduce caseload and improve the efficiency of the judicial system. As you might know, the Italian judicial system is not so efficient. So the main aim of the Italian legislator was probably to reduce caseload when the legislative decree was introduced. The legislative decree number 28 applies to cross-border mediation as well as to national mediation, even though I have to say that the vast majority of cases are cases of national mediations. It applies to civil and commercial disputes, so family disputes as well as labor dispute, criminal and administrative disputes are not included in the in this legal framework. In 2010, the decree made mediation mandatory for a significant set of civil and commercial disputes, arising a strong opposition of many categories. Lawyers and judges were on the front line. So in 2012, we had a first stop as the Italian Constitutional Court declared the original provisions of the decree to be partially unconstitutional, deleting the provisions imposing mandatory mediation. But in 2013, the decree has been amended and the new model of mandatory mediation has been introduced for more or less the same categories of disputes. And this new model is a very interesting model. It is a combination of mandatory and voluntary mediation, as we will see. And I would like to talk with you, to discuss with you about this new model. But before doing that, let me just share some basic definitions that are important. Well, the definition of mediation in Italian is mediazione, is absolutely consistent with the general definition we can find in the directive. I only would like to recall your attention on the reference to the proposal of the mediator that is very typical of the Italian model, as mediators can make proposal for the resolution of the dispute. Another important definition is that of conciliation, that is conciliazione in Italian. That means the settlement, the agreement concluding the mediation procedures. And there are specific rules governing the form and effects of the conciliations agreements. Other important definitions, of course, mediator, I won't go through the definition of mediator, is absolutely consistent with the general definition we all know. I just want to mention that to become a mediator, you need to have a bachelor degree, follow a basic training of 50 hours. Then you have to follow an advanced training of 18 hours every 2 years. But special rules apply for lawyers that have to follow a simplified training. It is important to underline that mediation proceedings shall be administered by mediations providers. There are public or private entities where the mediation procedure takes place according to the legislative decree. So we can say that the Italian model of mediation is an institutional model of mediation. And these institutional mediations works under the control, under public control, as mediation providers as well as training center have to be enrolled in the registry kept by the Ministry of Justice. And you can find all the information concerning the mediation providers on the website of the Ministry of Justice that control the works of the mediation providers. Now I can briefly illustrate the rules governing access to mediation according to the legislative decree. Well, we have 4 basic channels of access to mediation. The first one is voluntary mediation, as parties are always free to access mediation on a voluntary basis, provided that the dispute concern disposable rights. Then, as in Belarus, I heard, we have mediation clause. As parties may agree in their contract to attend mediation before they can arbitrate the dispute or file a lawsuit. And in this case, parties shall attend mediation. Otherwise, the judge, upon motion of the other party, might postpone the trial to allow the parties to attend mediation as they agree in their contract. Then we have court-ordered mediation, as judges at their discretion may order parties to attend mediation as a condition for the continuation of the proceedings. And they can do so at any stage of the judicial proceedings, even on appeal. Well, this is a very important provision, even though I have to say that judges have been quite reluctant in using this power, even though their attitude is now changing, as we will see. And finally, we have mandatory mediation. That is definitely the most important channel of access to mediation, as according to the legislative decree, mediation is mandatory for a significant number of matters, as parties shall file a mediation as a condition precedent for filing a lawsuit. Could be interesting to see which are the matters, the disputes subject to mandatory mediation. The Article 5 of the decree contains a catalog of disputes subject to mandatory mediation. So we have real estate, condominium, division of common assets, inheritance, family agreements, renting and leases, very different types of disputes, business lease, medical malpractice, libel, insurance, financial and bank contracts. So a very different arrays of disputes, to which it is interesting to note that a new category has been added recently that has to do with post-COVID disputes. At this regard, I have to remember that last July, the Italian Parliament has introduced a new provision according to which the parties to a contract, before filing a claim related to the breach of that contract due to COVID-19, for example, commercial tenants unable to pay rents or parties in general unable or unwilling to perform their obligation due to the pandemic, well, they shall attempt mediation according to the legislative decree. Obviously, the aim of the new provision was to avoid litigation in court. You can imagine the emergency had a very relevant impact on the efficiency of the judicial systems, but also to favor renegotiation of contracts as the best way to solve this kind of disputes. And it's interesting to underline that the new legislation has also introduced special provisions for online mediation and digital signature of conciliation agreements if parties cannot meet with the mediator due to the limitations imposed by the government regulation. Anyway, what does mandatory mediation really mean? Because this is very important to understand the Italian story of mediation. Well, trying to summarize, before starting litigation in one of the subject matters I mentioned before, the party shall file with a provider, with a mediation provider, a mediation request stating facts and reasons for the claim. Well, then the provider shall appoint the mediator and send an official communication to the defendant indicating the date and location of an initial mediation session. If the defendant doesn't attend this initial session, then the mediator only meets with the claimant, but shall only draft a certificate stating the absence of the defendant. And the defendant in this case will face light sanction in court. I will explain later why these sanctions are light according to my judgment. Obviously, if both parties are present at the initial session of mediation, then the mediator shall explain first the nature and function of mediation, and then discuss with the parties the possibility of entering in full mediation. If both parties agree, then the mediator shall effectively begin and parties shall pay the mediation fees. That depends on the amount in dispute. While if parties do not agree, then the mediator will end the proceeding and parties can start litigation in court without sanction. Even though I have to say some courts are sometimes sanctioning with cost, bad faith participation to this first meeting. To complete the story, what happens if the party does not attend mandatory mediation before going to court? As I said, the attempt is a condition precedent for judicial proceeding. That means that failure to comply with the condition precedent, that is, failure to file the request and participate in the first meeting, shall be raised by the defendant or remarked by the judge at the first hearing. And if the judge finds that mediation has not been properly attempted, then the judge shall postpone the trial and schedule the next hearing after 3 months so that the parties may duly attend mediation. And if they don't, the judge will then dismiss the case. If the parties attend mediation and reach an agreement, of course, the case will be dismissed. Otherwise, they can go back to court and the trial will continue at the scheduled hearing without sanction for the parties. So in sum, we can say that the Italian mandatory mediation model is a conditioned precedent as before going to trial for a significant set of civil and commercial disputes, more or less 10% of civil and commercial disputes are subject to mandatory mediation. Parties have a formal obligation to file a mediation request and participate in a meeting before a mediation provider. But it's also an interesting combination of mandatory and voluntary features, as parties, by participating in the initial mediation session, have the duty, but also the opportunity to meet before a professional mediator who will help them understanding if mediation is a viable solution for their case. So that after the first meeting, they can consciously decide whether to opt in mediation and attend full mediation before the mediation provider, or opt out and begin litigation in court, having fulfilled their obligation. And obviously, to fully understand the entire story, let's see some more details, in more detail, the rules governing the mediation proceeding and its cost. If they enter into full mediation, parties must attend mediation in person, but with the assistance of a lawyer. This is I think, peculiar provision, typical of the Italian system. It was probably a compromise of the Italian legislator to win the opposition of lawyers. So lawyers always attend mediation together with the parties. If the parties agree to enter in mediation, the procedure shall be concluded within 3 months, even though this is an extendable time limit. Informal rules applies, obviously confidentiality apply, and expert can be appointed during the mediation proceeding. If parties find an agreement, the mediator shall draft a mediation report and attach the agreement. The agreement is signed by the lawyer and is an enforceable title. If parties do not find an agreement, the mediator may submit a proposal, as I said, and the party who refuses the proposal might be sanctioned by the court if the judgment corresponds to the content of the proposal. As I said, online mediation rules have been introduced by the recent amendment related to the COVID experience. A few information about the cost. The cost of the initial session, the first meeting, is very low, while parties shall pay full mediation fees only if they enter in full mediation. And in any case, mediation costs are regulated by the law and by the ministerial decree. The filing fee, so, is 40 euros. No other fees are due if parties do not proceed after the first meeting. If the parties agree to proceed after the initial meeting, each party shall pay a mediation fee that is calculated upon the value of the dispute. The fee is the same regardless of the number of meetings. That is not very convenient for the mediators. And the success fee is due if the parties reach an agreement. Limited fiscal benefits are granted if the parties attend mediation and find an agreement. I won't go through this slide, but here you have the values of the fees that are due by the parties if they enter into full mediation, depending on the value of the dispute. So consider that each party has to pay this fee, and the mediator gains one part of the amount, as the other part goes to the mediation provider. I hope I have enough time. Just a few statistics. Statistics concerning mediation are annually published by the Ministry of Justice and are available on the website of the Ministry of Justice. Trying to summarize the statistical data of 2019, we can say that approximately 150,000 mediation have been filed with the mediation providers. That's not a lot, as you might consider every year 3 million of cases are filed before the court. 73% of these mediations are due to mandatory mediation. This is why it's important. Only 14% is court-ordered mediation, but the percentage is growing. 11% is voluntary, and only 0.5 is contractual mediation, coming from contractual mediation clauses. Success rate in general is quite low, especially if compared with what we saw before. We can say that if we consider the entire amount of mediation filed every year, the success rate is 14%. That is very low. But I have to say that it's not only fault of mediation, because we have to consider that in only 50% of cases, the defendant effectively shows up at the first meeting. So in 50% of cases, the mediator can only end the proceeding with the certificate stating the absence of the defendant. But the success rate grows when both parties participate, and grows even more when parties agree to sit at the mediation table after the first meeting. But a lot depends on the subject matter in dispute, because, for example, in bank contracts or insurance contracts, the percentage of success is quite low, while it's definitely higher when we talk about division of assets, succession, or condominium. So, is the Italian story of mediation a successful story? As in many other aspects of mediation, my answer is it depends. In terms of caseload, cost and delays reduction, I would say that yes, mediation is not really successful. The answer is only partially positive. The statistics tell us that in the last decade, there has been a reduction in the number of cases in general, and that the reduction has been more significant in those sectors where mediation is mandatory. But as I said, the number of agreements reached in mediation while growing is very limited, especially if compared with the number of judicial proceedings pending before the Italian courts. The fact is that, as comparative experience tell us, mediation works well where the judicial system is efficient. When the judicial system is not efficient, and as it is not efficient in Italy, mediation is not so efficient, as there is always one of the parties who may be interested in not mediating and in taking advantages of court delays in order to delay payment or compliance. Therefore, at least nowadays, we can't expect mediation to be a successful solution for the inefficiency of the judicial system. But a different conclusion can be drawn if we look at the question of successfulness from a different perspective, that of culture and knowledge. I think that mandatory mediation was a very interesting solution to force parties and lawyers learning and experience what mediation is. In 2010, no one knew what mediation is. Now lawyers know what mediation is. Parties, what businesses and consumers know what mediation is. And even mediators had the opportunity to make experience with thousands of mediations. So it is another way around as compared to the Netherlands experience to reach the result of the spreading of culture of mediation. And I think, just to conclude, that the new provision concerning litigation, post-COVID litigation, will be a very interesting testing table, as I think that this mandatory provision might be very helpful in convincing parties about the opportunities offered by mediation during such an exceptional moment as the one we are living due to the pandemic. Thank you very much.
Thank you also, Francesca, for a great presentation. It's always hard for those who step the first to the road, to the new road, and Italians were so brave to try this mandatory mediation, and of course that's why you say that there were some good things, but there were also some risks that you took. But the result is very, very interesting and very, very interesting for us to see, because we Lithuanians go the same road of mandatory mediation. And Francesca, we have a question to you from the auditory. Of course, maybe you have already reacted to that aspect, but let me ask you, from your practical experience as of mediator, how do the parties react to the proposal from the mediator? Isn't it perceived as a coercion with mediation, especially knowing that the parties may face sanctions for not accepting it?
Yes, I have to say that always from a statistical point of view, the number of proposals by the mediators is very low. So we try to do, all the mediators have been trained in facilitative mediation. So it's quite rare that mediators make a proposal. It is an important provision, of course, but I have to say that in general, we don't make proposal. And yes, it's true. Parties are quite afraid of the proposal of the mediator, and this may create some confusion in the parties. When we present mediation, we talk a lot about the voluntary nature, and this idea of the proposal. We talk a lot about the confidential character of mediation, and then if we introduce the issue of the proposal that can go to the judge, this can be contradictory. I have to say, though, that in my experience, sometimes the proposal by the mediator break the impasse. It can be useful to break an impasse. I don't know if it's typical of the Italian behavior, but some parties and some lawyers are very litigious, and sometimes it's very hard to find a solution, and sometimes the proposal might break an impasse.
Thank you so much for your answer and for your great time with us. We are moving back to Lithuania.
Taip, iš tiesų grįžtame į Lietuvą. Dėkojame užsienio kolegoms už paskleistą jų patirtį mediacijos srityje.
Yes, we're going back to Lithuania. We are grateful to our foreign colleagues for sharing their experience and their insights, but in Lithuania we also need to have other experience, also other insights, and we are welcome Jurga Greičienė
ir ankstyvosios intervencijos modelio skirto vaiko gerovės sistemos stiprinimui.
Bendra psychologist
mediacijos technikų įvairiausių. Šalis jas naudoja ir mišrės naudoja, o mediatoriui reikia susiorientuoti. Be jokios abejonės visada reikalingos pakankamai gilios arba intuityviai svarbios psichologijos.
Well, we always need psychological knowledge, which could be quite intuitive and deep enough to carry out mediation. And now the floor is yours. Thank you so much. I'm very delighted to receive this information and to have an opportunity to share my knowledge in the field of psychology. And I will try to give you several ideas which come from my personal practical experience, because last autumn, within this excellent project, I happened to share my knowledge and to participate in several events and communicate with the judges. It involves empirical experience, practical experience, who also tried out mediation activities. I believe that The best way to start this presentation is to give you a quote from the speech given by Abraham Lincoln to the lawyers. Discourage litigation. Persuade your neighbors to compromise whenever you can. Point out to them how the nominal winner is often the real loser in fees, expenses, and waste of time. As a peacemaker, the lawyer has a superior opportunity of being a good man. There will still be business enough. So it was quite early when it was understood that an amicable resolution of disputes pays out in the life of lawyers. And actually, mediation in itself is an activity which combines two large and important areas of activity. It's law and psychology. So the synergy of law and psychology in mediation provides an opportunity to introduce a human dimension into formal law. And also it strengthens the understanding that we can solve the disputes amicably when we take account of individual needs and we adhere to the legal standards. The success of mediation and constructive effects also depend on how professional the mediator is, how well prepared mediators are, and regardless of the profession, whether it's lawyer, psychologist, social worker, or something else, it's the responsibility and duty of every mediator, because we are professionals, both in the field of mediation and our own professional field. Judicial mediation is neither the proceedings nor psychotherapy. The mediators must be able to use different tools, different methods, psychological techniques to reach an amicable agreement. So legal knowledge, practice, ability to apply legal knowledge are both equally important in terms of the competences. As I mentioned, last autumn, last year, I happened to share my experience with the 150 judges of Lithuania, and it was the training called Mediation in the course of the Republic of Lithuania. So what happened in the training courses, it involved the reflections of the judges, and the participants said that there was a lack of psychological skills, lack of training courses, lack of application of techniques, lack of training or workshops on how to apply the learned techniques. In terms of the training experience, there are several important aspects for mediators or for mediators to be. Excellent legal knowledge, of course. Maybe it's my own experience because I had to learn a lot in terms of law, but still ability to apply knowledge in practice, also experience in the resolution of disputes, when making decisions, law-based decisions, also will help the parties to resolve the disputes amicably. Also the will to reduce the caseload. Also the will and need to know and be aware of more psychological aspects which can be helpful and applied in the mediation process. And one more thing was expressed by the participants, it's the will and need to share personal experience, both in the work of the judge, both in the application or preparation to apply mediation. So first of all, everyone must be human. That was the insight expressed by the participants of the conference.
Turinčių mediatorių gretose ar besiruošiančių, tai vis dėlto išlieka labai stipri orientacija ginčo sprendimą.
One more thing which is really prominent and prevailing among the lawyers is the orientation towards the solution of the dispute when making a specific decision. It must always be based on law, and very little focus is placed on personal experience, on beliefs, on emotions and the needs. It can also be an inclination to a reasonable, direct the parties towards the right decision when true needs and emotional status of the parties are not taken account of. So mediators must be more thoughtful, must be more considerate. Also, too little responsibility is assumed when it comes to the judgment or decision in the dispute or result, because the practice requires the decision to be made, and then the parties lose the opportunity to act freely, and the mediators really become fully responsible for the final decision, which should not be the case. Sometimes it's very difficult to keep the distance, to be always impartial when you have the status of the judge, or when you are a mediator, or when it comes to the lawyers. It's not always to put it aside. One more important thing is about the management of the process. There's a lack of practical interviewing or process management knowledge. There's a lack of psychological knowledge, especially those specific, especially the specific, not generic knowledge, for example, personality types, personality traits, behavior, special behavior, and there are limited possibilities, little experience when it comes to reflecting your own experience and improving the skills of a mediator, let's say in supervisions or personal therapies. So self-reflection is not a usual process in the community of lawyers. It also relates to the fact that there's a lack of self-recognition or self-knowing, self-reflection, because these aspects are also very important for the process of mediation. To sum up, psychology and mediation cover self-knowing, self-recognition, self-cognition. When you know what type of a personality you are, what your behavioral traits are. And here I want to single out several postures or several stances which are very important in the behavior of a mediator. One of them is a position of being unaware. That means when a mediator accepts every situation as completely new, when you have no knowledge about that situation, no prejudice, no beliefs. And this allows demonstrating practical, active listening, being interested in what you hear, and this so-called wise curiosity of a mediator. It means being very attentive, it means being considerate, and it means speaking in questions and not statements. It resembles being a child when you want to know everything by asking questions. Another thing is the tolerance of uncertainty. It's a personal quality, personal trait. It's an ability to accept something that you cannot plan in advance. It means an ability to accept the situation and to accept the circumstances as they are. It means tolerating the unpredictability and remaining emotionally stable, because the process of mediation is full of unknown, full of something you cannot expect, of different reactions, emotional outbursts, and many unpredictable events, because mediator is something of an extreme, who is ready to dive into personal relationships between other people. And in the process of mediation, it allows mediators to be here and now and to be very active in reacting to what is happening to people here and now, to be very flexible in changing different strategies. And it's completely different from what is happening before the court. And here at the court still you can maintain some limits, which is sometimes impossible in the mediation process. And what Manuel Kant said, if a person is good, if men are good, they will still herd the sheep. But thanks God, we're still negative a little bit, and we have some animosity towards others in ourselves. So people, when they encounter these situations, when they are endangered, when they are at risk, they can sometimes, despite the consequences, despite the behavior, be very unpredictable. So when they encounter these situations where they must recognize that they lost, that they are wrong, they can take the most risky actions. And this particular phenomenon is very frequent in mediation. So mediators must be ready for everything, and they must be aware of the fact that it's only natural, because people are different and they have to find ways of how to direct the people into the resolution of the dispute, but to accept people the way they are, because otherwise that would affect mediation. Mediators must be able to simultaneously perceive, realize, feel, and manage two or more human realities. They must be able to understand the individual human reality. They must be able to reflect every reality of every party to the other party so that it becomes understandable and acceptable. And the mediators must be able to help the parties to create the vision of two different realities that would allow the parties to reach a decision in the dispute. And when we think of the competencies, it's very important. It's self-education, it's workshops, different workshops on personal improvement, also personal consultations from the psychologist or psychotherapist. These are not usual, but really very helpful. What else? These are workshops on communication, on improvement of communication skills, also specific knowledge, which is very important, fundamentally important in this work. It involves types of personality, different personal traits, and all mediators have to understand that permanent, regular supervisions are very necessary to keep them informed, so to say. So they have to conduct professional consultations. As our philosopher, Dr. Baranova, said, to become what you can become, you must take a risk. You must walk a tightrope. Thus, spoke Zarathustra. When a tightrope walker walks on the rope, he takes a risk because he can fall anytime, but he cannot stop because he will either stop and fall nevertheless. So you must take risks and try to become what you can become. And maybe the most important thing, you must have a sense of humor. Maybe that's the most important competence of all in the work of mediators. And you must always ask, how can you see the world? How is it important to ask questions? And it's a very short extract from the film. I'm sure you are all aware of. It's from Dr. House. It will be in English.
Just make mistakes. Anna, you need to try twice as hard to fix them. Are you using your inhaler?
All the time. Go through one a week.
You sure you're using it right?
Do I look like an idiot?
No. Why don't you show me how your inhaler works?
Jerk.
Taigi, matyt, tai iliustratyvi pabaiga. Ačiū visiems.
So that was a very illustrative ending, and I hope that several insights will help you to take that risky road and to become excellent mediators. Thank you so much for your presentation. You provided many helpful insights and pieces of advice, and I believe it's an ABC for every mediator when it comes to working with specific cases. This work is very dynamic indeed, and maybe we can conclude that there's no universal technique, there's no universal style in mediation, even if you are prepared for it under the circumstances of the case.
Yeah, we can confirm that there is no specific technique to deal that. Because the psychological aspect of the legal proceedings require constant attention and seeking on every second what kind of technique should be applied, because this toolbox to be available to each mediator is really large. On the other hand, this is an ability to respond, not from legally, but just respond to the ongoing process. And the process is just to ensure that people achieve certain settlement. Sometimes you can achieve an opposite result. Sometimes, quite unwillingly, we can trigger some animosity. That's why there is a lot of responsibility on the shoulders of the mediator. I can only confirm that every mediation process is a jazz-like challenge, improvisation, because you never know what's going to happen. That depends on a lot of things. It's a verbal behavior, the behavior on the part of the parties, and mediator has to be always alert. So the question is it possible to learn this psychology, or is that a given, some kind of God gift of the person that is able to be able to understand what's happening in the heads of the parties? Yeah, certain things can be learned, some things can be learned faster, some will take more time, depends on your background experience, and it's important to understand when taking a decision to go into mediation. It's do you, as a person, like to play jazz? Do you mind being in some kind of undefined situation and be able to improvise? Maybe there are many places, many areas of activities where we can do that, but not in mediation. So to sum up, you can learn, but the important thing is to understand yourself, what kind of character you are, because it is a downstream swimming, but you cannot sink. You cannot drown. You have to go down the flow. So you have a lot of responsibilities too. So mediator has to take care of himself, not to get too engaged, because there are many other people who can just suppress you with their psychological behavior, and the personalities are very diversified and they're able to manipulate. So there is always a danger to get drowned. So we are now swimming down the stream. What would happen if you had to go up the stream? So that would be much more complicated. So thank you very much. So we are a little bit late for our lunch, but we have our lunch until 1:10 after. Please enjoy your lunch, and we'll be happy to see you back after lunch.
Sveiki visi sugrįžę į tarptautinę praktinę konferenciją Mediacijos sėkmės istorija ir jos kaina. Tęsiam pranešimus ir studijoje pas mus yra lietuviškas ekspertas.
Let's come back to the conference, and now the floor will be given to Giedrė, a mediator, lawyer, lecturer at Mykolas Romeris University, and he's been conducting training for mediators as well. I can only confirm that Giedrė is very active in the field of mediation, and without any doubts, his presentation will be very interesting. It's called Mediation in Civil Justice in Lithuania, Challenges and Prospects.
Thank you very much. Welcome to all the audience and the viewers. In fact, mediation in civil justice, the mediation in civil justice as a phenomenon is a very dynamic phenomenon, because mediation by itself is a new institute in the legal system, and it's very new in Lithuania. At the very beginning is marked as the resolution of the Council of Courts in 2005, and it was the first challenge. It was the first challenge for the legal system, for the legal framework, and the challenge for the mediation. But at the same time, it opened new opportunities, because challenges and opportunities and prospects are very closely interrelated things. And why? Why? Because when you face a challenge and you overcome the challenge, you will always find some new ways, some new opportunities, some new prospects. And in this area, what we can do is we can see how mediation, as it is improving, but in Lithuania, we face significantly serious challenges with mediation. Just from the very 2005, the very challenge was to introduce mediation in the Lithuanian legal system, is to help people, business, to understand that it's a good thing. And one way or another, say that this challenge is kind of protracting. So from 2005 until 2014, it was some kind of intelligence activities. There was some kind of training, some kind of discussions, but only in 2014 there was some kind of breakthrough took place when first mediations were recorded. The numbers were going up, and I can say that we have overcome that challenge, and mediation started working in Lithuania. Opportunities and prospects are now innumerable. A lot of judges were trained, and other people who liked mediation, those who advocate mediation. The numbers by themselves show that mediation is establishing itself in Lithuania in civil law. In 2019, more than 500 cases were closed by way of mediation. Starting from 2020 January, Lithuania has been facing another challenge, the challenge that divided the legal community, theoreticians, practitioners concerning the mandatory mediation. But the very principle that this mandatory mediation concept came into existence is a huge challenge for the state and for the legal system. We accepted the challenge, and at the same time we accepted the prospect. So
beveik 5,000
by 1st of September, we have received nearly 4,000 applications concerning mandatory mediation, and that shows that we have taken the right decision. And 10% of the applicants concerning mediation, so that is about 500 cases, were closed with settlement agreements. Maybe that is not a huge number, but for Lithuania, that is a significant number, especially having in mind that the disputes were mostly of one category, and knowing the total number of cases that we receive, about 200,000 cases that are filed to courts in civil cases. 500 of course, is just a minuscule number, but it opens new opportunities. Maybe for me personally, maybe I feel really sad in a way that out of 4,800 applications, only 160 were initiated at the common agreement of both parties, while the rest were initiated at the initiative of one party. That's why I believe that this challenge is really significant. The challenge that needs to be implemented in order to turn the number upside down, so that the most of applications are filed at common agreement. Because the mediation process is not the process that mediation has to look for parties to take advantage of mediation. Mediation is a process, and the goal and the measure for the people to take advantage of and for people to use it. Speaking about civil justice and business, business has broad, vast and unlimited opportunities to find agreement, and business has to look for mediation opportunities. Not mediation has to. It's not mediation's task to train business, but vice versa. That's why it's kind of a global challenge to the mediation is to change the attitude. To change the attitude and to show to the business that there is an opportunity that can be taken advantage of. That's why today when I hear some discussions about mediations, about discussions about mediation, I can see that we don't fit anymore in those standard frames. That it's not sufficient now to introduce mediation as a branch of law, as a profession. We are speaking and discussing about cultural relations within the mediation process, about the international mediation process, about such innovative things as the application of neuroscience in mediation, and also about how you can apply artificial intelligence in mediation, and that is in the international sphere. So international mediators think in those categories, and we are facing a huge challenge because mediation has to catch up with that dynamic opinion that is so characteristic of the area. Speaking about Lithuania, we need to say that after the mediation law was adopted, mediator became established as a profession. There are some responsibilities. There is a mediation evaluation or assessment commission. And I would say that but today we see a new challenge in front of us, and I, as being a member of the Commission for Mediation,
see a
kad
great challenge,
visuomenė,
meaning that
visuomenės nariai, kurie
society,
dalyvauja
members
mediacijoje,
of society
dar
that take
ne
part in
visai
mediation do
supranta
not
mediacijos
fully
procesą ir
understand
trūksta
the
to
mediation process,
teisinio
and what we
raštingumo,
lack is
nes kartais
legal
ne
literacy,
taip
because
pasakytas žodis,
sometimes
ne teismo
the word
nepatvirtinta mediatoriaus ruošta
that is
taikos
said
sutartimi,
wrongly
taikos sutartis tampa
or
ginču tarp
settlement
mediacijoje
agreement
dalyvavusių
become a
dalyvių
subject
ir paties
of the
mediatoriaus.
dispute for the parties to the
Natūralu,
dispute and
tokią
mediator
perspektyvą
themselves.
mes,
It's
manau,
only
numatėm
natural that
ir galėjom
we've
numatyti.
envisaged
Iššūkis yra
that
su tuo
particular
susidoroti,
prospect, and our
o
challenge
tam, kad
is to
susidoroti, tai
tackle
čia
this.
toks gal pajuokavimas,
And
kad
to
jau
deal
ir
with this
draudimo bendrovės tapo suinteresuotos ir sako, jeigu jūs
can
jau
be
kaip mediatoriai esat profesija,
illustrated by
tai
this
mes jum
example.
galim ir
Let's say insurance companies say
atsakomybės tam
if
tikros
you
draudimą
mediators
pasiūlyti. Ir jau,
are
sakykime, tokios
professionals,
kalbos
meaning
ne vienoj
representatives
diskusijoj
of
buvo kilę, kad
of a
mediatoriai
certain occupation, then you can be offered certain
reiškia draudiminių santykių dalyviai
provisions.
tam, kad apsaugoti
So
savo
that means that mediators
atsakomybę,
can be
jeigu
insured to protect their
nežinau,
responsibility,
dar kokiu būdu
their
padarytų
liability,
žalos
if
mediacijos
they
proceso dalyviams. Tai iš tiesų tie iššūkiai, kas
are
kartą,
accountable or
kai mes
liable
juos
for some
įvykdome,
damage
kas kartą, kai
which
mes juos
occurs during the
pasiekėme,
mediation process.
mes
So
kartu
every
atrandame daug
time
galimybių,
when we reach
daug
our goals,
perspektyvų.
we
Ir
find
geras
new
pavyzdys tuo, kas
prospects,
vyksta dabar,
new
iš tiesų
opportunities.
šeimos
And
ginčuose
a very good
nuo
example
metų
can be
pradžios iki
found
rugsėjo
today,
pirmos beveik
let's say, in family
5 000
disputes.
prašymų. Tai yra didelis skaičius.
For example,
Sėkmės istorijos
up till now,
10%
there have been
reiškia, kad
5,000
10%
requests
bylų
coming from
nepasiekė
families, which
teismų.
means that
Nepasiekė teisminių
a
ginčų
high
stadijos. Šalys
percentage
sugebėjo
does
susitarti
not
ir
reach the
surasti
courts.
bendrą
This means
konsensusą
that the
tarp tų
parties
klausimų,
managed
kurių
to
ginčų galbūt
find
nesutarė.
a solution,
Bet
find
yra
an
kitos
agreement, and
galimybės,
find a
kiti
consensus.
iššūkiai.
But there are other
Ir aš
challenges, and there
asmeniškai
are other
manau,
opportunities.
kad
I
iššūkis yra
personally
ne tik
believe
šeimos ginčus
that
įtraukti į mediaciją.
we
Iššūkis
need
yra
not
įtraukti
only
ir
to
kitas
involve families in the
smulkūs
mediation,
ginčai,
but also we need to
sveikatos
involve other
priežiūros
types of
srityje,
disputes in the mediation,
kurie
let's say
lygiai taip pat, kaip ir
healthcare or
šeimos ginčai,
small
pagrinde
businesses,
remiasi emociniais
which,
dalykais.
like
Ir
family disputes,
ten lygiai
are
taip
based
pat aš
on
matyčiau
emotions.
sėkmę, nes atstovaujant
I can see
vieną ar
success
kitą
in
pusę
those
tokio
fields
pobūdžio
because when we
ginčuose
represent
matau
one
daug
or other
galimybių
party in
susitarti,
such disputes, I can see
tačiau
many
patys
opportunities to reach an
principai,
agreement.
gal žmonių
But the
nesuvokimas
principles
to dažnai
themselves,
padaryti
or
neleidžia.
maybe a failure to perceive mediation as an alternative,
Galbūt
are
apibendrinus
obstacles
tą
for
visą
this.
dalyką,
Maybe just to sum up mediation in civil law, the challenges and opportunities, maybe my conclusion would be that all those restrictions or limitations, reservations that we see is actually just our imagination, and as much as we can change our imagination, the more mediation will be changing, and as long as we can face the challenges, we'll have new prospects, and I can see a lot of prospects in the future. Thank you very much for this concise presentation. We so far don't have any questions from the audience, but Natalija has a question. I have a lot of questions usually. I would like to refer to your main profession. You are an advocate. Like mediator is like a side profession. Parties are encouraged to take advantage of mediation because it's a free procedure. Courts are also willing to engage in that just in order to reduce their burden. What can be done to engage advocates in this process? Yes, that is a challenge. Not not only for the entire bar profession, but also for me as a mediator and advocate. It's a challenge in the sense that not all representatives of all institutions are not always friendly and willing to allow the parties to express themselves, but how to catch them, how to engage them. Maybe the main thing is to change their approach, their stance, because the main stumbling block that I keep hearing at trainings or discussions is that mediation takes part of the work from advocates, but looking at the statistical data, we can see that mediation really accounts for a minuscule part of the total number of changes. Maybe not all understand the process, maybe not all understand the benefit of the process. So maybe we should promote training because let's say when I teach at training sessions, I see very few advocates. Maybe they don't want to, they don't understand, but still I have some good examples. Many of my colleagues, advocates, years ago were saying they don't understand the meaning of mediation. You didn't know what the benefit was from that, but today they think today they know what mediation is. They know whom to apply to ensure that mediation is a successful process. They know the professionals in mediation, so we can say the personal example and education and training still yielded some results. So the success stories is the best thing to present something, a story. So maybe you have some kind of success story anonymized without disclosing their personal data, where you succeeded in persuading the parties to have a settlement agreement. Yes, there are some success stories. Some of them are very different. Some of them were successful. Then that was a huge incentive for me, myself, personally, to get engaged in the mediation process, because my first co-mediation case, together with a judge from the Lithuanian Court of Appeal, was very successful, and the dispute was concerned also the family law, so that was very inspiring, very encouraging, and we felt very much motivated to continue working in that area. And then there was a row of other experiences in failures and successes. Maybe the most remarkable case was when maybe my colleagues will not get mad at me because of that, but I would say that parties agreed only when advocates left the room. Because the parties were complaining that they couldn't agree because they were receiving the wrong advice. But advocates left, and the parties to the dispute said, understood they are responsible for their own fate, because they understood that advocate will not be here in the future. He will not be living the situation or the problems. And the most recent story that was extremely successful, and there was a success story also from the state guaranteed legal assistance. So So
sakau, kodėl jūs kreipėtės ir kodėl atėjote.
the case was referred to me from that service. And they asked me just to check whether the settlement agreement was really a proper one. Yeah, so as the psychologist said to us before the lunch break, is that in this business, every second is a new surprise and a new challenge. And it is it also shows that the mediation is a tool to get reconciliation even before the litigation process. Thank you very much for your presentation. And we have received from the audience also feedback that it was a very interesting presentation. And our next speaker is also a Lithuanian, Gintautas Sakalauskas, Dr. Gintautas Sakalauskas. He's an assistant professor from Faculty of Law, Vilnius University, the author of around 90 publications. And he will be speaking about mediation in criminal law.
We've been speaking of mediation and administrative proceedings, but mediation is not new in criminal cases as well. Thank you so much for invitation. I was very delighted to receive it. The conference acquired this particular format, and I'm very happy about it because mediation is very close to me in my heart, but very far away in my mind. Why is that? Because I graduated from law studies Lithuania 20 years ago, but while studying I moved to Germany, to Dresden for a year, and there I studied in the higher education school of social work. At the time, it had a course, social work and criminal justice. So I spent 2 years studying that particular subject in Germany, and I saw a different perspective. It began with the prosecution and how it looks like from the perspective of criminal law. And then I saw that I was damaged a bit because I understood that it was not the law, but a person that was the most important thing. I also consulted mediators. I attended different courses on mediation, on family law consultants, on criminal case in Germany, because mediation was introduced in criminal cases among the criminal cases related to young people, to the youth. And then there were publications about its undoubtable success. After that, I returned to Lithuania, but while being in Dresden, I started preparing my paper on the problems of mediation. And I thought it would take only a little time and we would have the same situation in Lithuania, like it was in Germany. And the structure of my presentation is my personal context and mediation. I elaborated on it a little bit. And then mediation in criminal cases, advantages and assumptions for development. Then non-success story in Lithuania. Why? And then discussion. Possible shifts and prospects. So moving on with the personal context, the publication, which was published in 1998 on the Reconciliation Institute in the law of Germany. I thought very sincerely and honestly that the same would happen in Lithuania. But I was wrong. and I will explain why. It was also very disappointing that when I started working in the Law Institute, headed by Antanas Dapšys, we were drafting a new criminal code, and there were a lot of proposals proposed by the representatives of minor criminal cases and representing other fields of law. All of us suggested including a mediator in criminal cases because everyone understands that mediation needs a mediator, otherwise the case is just terminated and that's all. At first I didn't understand why people were so skeptical about it, why they were so not willing to understand. And other personal things also relate to the times when I was working in the Institute of Law. We were organizing the first mediation seminar for family disputes. My family, my friends, colleagues, mediator Joachim Neufeld, now late mediator, and mediator Professor Dr. Inga Maria Neufeld. Also conducted the workshop. It included many other professionals from Lithuania, and it was really a successful one. I don't know, maybe the participants became mediators and still work as mediators, but still the format was unusual, and it was held in 2001, and as far as I know, that was the first seminar, the first workshop dedicated to mediation. My colleagues Rimantas Simaitis and I also took part in the research coordinated by Greifswald University. It was dedicated to restorable justice, and this research involved universities from 36 universities from European countries, as well as scientific institutes. And that was the last disciplinary touch to this field. That's why I'm saying that in my mind it's so far away, but in my heart it's a very close subject to me. In criminal law, justice needs to be understood in quite a different way. It's not only a sword, scales, and your eyes shut. You need to untie your eyes and you must see everything very clearly. And to make mediation widespread, we need many conditions, preconditions for that. So what do we see in the countries where mediation has been applied in criminal law and criminal justice for a very long time now? It involves something that I knew, especially after the studies in Dresden, and it also involves something where it comes to passing your knowledge, passing your experience over to your colleagues. First of all, it involves frustration. Everything happens in a more difficult way than in other fields. It comes to building mutual trust. It means trusting each other, and it also means always quite different ways of solving a criminal dispute. And very often Mediation works quite differently to the proceedings heard before the court. Also, the participants have an opportunity to speak in their own language. They can express their needs. And everyone knows how legal jargon, how legal language is important, but when ordinary people do not understand lawyers, then the situation can become more complicated. And here all participants can speak in their own way, at their own pace. They see the victim that is violated, that is is an aggravated, aggrieved party in the proceedings. And it is always very complicated when it comes to minors. Then I happened to take part in 2 informal mediations when victims are very angry. They ask for huge amounts of money for the damage they've been made. And after several sessions, an apology is enough. So what mediators have to do, they need to return that feeling of security to the victims. Also, the participants are free to choose the procedure and conditions of the mediation process. Again, there's an encouragement to adhere to the standards. And it was determined that after the mediation processes, the opportunity of recidive is quite lower. And again, the financial costs are lower as well. And these are undoubtable things. Of course, there can be some adverse effects, but still these are prevailing factors which have been identified, determined by some studies and research. What about non-success story in criminal cases? I singled out 12 points here. I referred to sources of literature, to experience of other parties, to the situation over 20 years in Lithuania, and I was trying to answer the question, why are we unsuccessful here? I happened to give one presentation in Krasnoyarsk when there was an international project. The topic was very similar, and I was saying it is very difficult in our countries because our climate is not that warm and banana trees are not growing here. And our Russian colleagues understood this particular point very well in terms of being aggressive, in terms of imprisonment duration. It's very difficult to grow something that grows naturally, let's say in the Netherlands, where they have good, favorable democracy, widely accepted by their society. Culture is very important. What we have is, in terms of our relationship, in terms of how we imagine imprisonment and punishment, comes from hundreds and hundreds of years ago. When it comes to a critical attitude to formal prosecution, again, we need to form a science-based stance. We need to see the advantages of criminal law, but at the same time, we need to see what prosecution fails to reach. It's excessive contribution of professionals to the proceedings. Again, it's not only a conflict between a criminal and the state, but still we treat this criminal activity that it was committed against the state, but this is not the case. That's why in Norway, let's say, mediation is much more successful. Here we have the state stealing the conflict from people, but if we want to have mediation as a successful process in criminal cases, then we need the state to bring the conflict back to people. Again, let's not forget stereotypes and labels about people who have committed crimes, who did their time in prisons and so on. So we must let them come back to society. In terms of non-judicial mediation success in civil and family cases, of course, it's not the judge who should be responsible for that. And mediation will never be successful in criminal cases unless it is such in civil and family cases. We need to pay attention to professionalism and competencies of the mediators. We need to be very clear about organizing mediation and financing the processes. We need to identify. We must be very clear about the identity and representation of mediators. We need to ensure political support. We need to be aware of the advantages of mediation. We need to make sure that the prevailing professions are not resistant to mediation, that they see all benefits, all advantages brought by mediation, because many sectors do not want to do anything with mediation. And of course, we have to disseminate good practices. Only then mediation will be applied by others. And now you can see your barometer, which shows that we don't trust legal systems, and Lithuania is no exception. It's somewhere in the middle, but you can see that people do not trust legal system. And to answer the question, how much do we need to improve an independent accessibility of the courts? Here in Lithuania, we say that we need great changes. And why, when we don't trust the legal system as such in general, why don't we create something similar to mediation that would be effective in all this? Thank you so much for listening. If you have any questions, I will be happy to answer them. Yes, we have questions, and yes, your time is limited. But here is a question. Could you point out peculiarities of mediation when there's violence in close environments? How is it efficient? How much is it efficient to defend rights of the victim? A very good question. I'm very skeptical about mediation when it comes to conflicts between family members, between relatives, especially when it comes to violence in a close environment. Then, of course, there are many exceptions, but mediation is effective when there are no long-term relationships between people. But when, let's say, people live together for 10 or 15 years, there are many disappointments or failures or something else, and then mediation is too easy, too artificial to resolve a dispute, to resolve a conflict. My German colleagues say it's better for them to go to a family consultant, psychotherapist, in order for them to reach something and to resolve the disputes. And mediation has only several sessions, 2-3 hours each, but the conflicts are too deep-rooted for them to be resolved that easy. So mediation is a tool which is too easy for solving very deep conflicts. How could mediation be incorporated, integrated in a legal system as a tool of a criminal law? Or should we change the entire system? Well, let's say we have a prosecutor and he could say whether the case is eligible for mediation or not. Let's say in other countries, in Germany, there are municipal councils, non-governmental organizations, which are somehow funded maybe from ministries or some other institutions. Then they build relationships with other institutions or regions, and the prosecutor says, okay, we can terminate the case and refer it to the mediation. And now it is done, maybe the process is similar what we have now, but we still need a mediator. And the problem is, let's say in civil law, everyone understands that the court cannot solve a verdict and then refer the case to mediation. And now we see that the court decides on probation and then sends or refers the case to mediation. So that's not a good way to do it. And let's say if mediation is not as strict as probation, it still wouldn't serve as a means to have an opportunity of avoiding punishment.
So, one more question. In your opinion, how feasible it is that the accused, that the perpetrator reconciles not with the victim but with the state. That is not impossible. There must be a person that represents him. That would be a manager. If there is an institution representing the state, let's say the state tax inspector or something, so there should be some very clear interest. There should be interest. That should be some kind of personal victim. If there is no personal victim, so yeah, why not? But I understand that confidence in public authorities is needed here. So this word confidence, trust is a key word for many problems, to tackle many challenges in Lithuania. So thank you very much, and we will have a chance to speak to you during our panel discussion. So that was a very interesting view that we heard from this most recent presentation, is that mediation is a too simplified tool to tackle disputes in family law, but it's more in business. But the fact is that in the situations that are loaded with emotions, most loaded with emotions, the more reconciliation is received.
Dar vienas lietuviškas pranešimas, labai gražu, Egidijus pristatė civilinėse ginčuose mediaciją. Gintautas pristatė baudžiamojo justicijos, na ir dabar paskutinė iš Lietuvos pranešėja.
Civil mediation, in civil justice, in criminal justice. Now the floor is given to assistant professor
Neįtikėtina, bet akivaizdu.
Salvia Mulevičienė, but mediation in administrative justice, challenges and opportunities. So that is unbelievable, but that's true. Earlier it was believed that mediation is not possible in administrative law, but it is true. So Salvia Mulevičienė is an active participant in research area. He is a speaker in many conferences, and speaks about mediation in administrative justice. Challenges and opportunities. Dear participants of the conference, I would like to present the structure of my presentation. So I'm going to speak not only about mediation in administrative justice in general, but also the costs and other things. So the first thing that I want to tackle is how the issues relating to mediation in administrative justice are being tackled, why this situation is being observable in Lithuania. Are we very different from other states? Are we very different, exceptional? Also to think why this kind of model was selected in Lithuania, and also we'll be speaking about the objective, what kind of path we should be choosing just to make our life a little bit simpler. So, my first thing is the overview about the administrative disputes, and does mediation have any place in here? So, is there any model for mediation in this area, and why that model was selected? So, the first is arising and course of an administrative dispute. So, some dispute concerning the failure of some administrative institution. So that is the very first level is taking the decision within the institution, and the next step is review of the peer review of the decision within the institution. That is according to the administrative law, because the law provides for a possibility for the institution to repeal the same decision. So in this place, many states actually consider this the very cornerstone for the mediation, saying that this is the place where mediation should be introduced, so that so that the parties wouldn't have to apply to court and maybe to overload the administrative system with unnecessarily conflict situation. The next stage is the pre-trial resolution of an administrative dispute. So this is something that was mentioned by our representative of Ministry of Justice, that starting from next year. In Lithuania, the pre-trial mediation will be introduced in Lithuania, where such disputes will be solved at the level of administrative dispute commissions. We have not only the administrative dispute commission, but we have other institutions. So one of them is the tax dispute commission. Also, there is the labor dispute commission, employment dispute commission, but they will not be included in the project that's going to be launched next year. So this resolution of administrative disputes by mediation is a novelty in Lithuania, and it has focused on one subject. Later, I will speak about the reasons to select this model. And the third stage, if the dispute finally can be referred to court for the final resolution. So that is like a third stage, but in Lithuania we started from the third stage. So mediation was introduced in this legal process starting from 2019, where certain amendments were made in the legal framework. So we are now having certain results already. So we can now look at the situation to see why we have three stages. And And we have created already the second step, that is the pre-trial resolution, but it is not widely used within institutions. So a lot of those issues are related to challenges in administrative law because there are differences as compared to the civil law, where mediation has already established itself, both in media and in the press and the media of the parties and also the foreign papers often speak about whether or not we can speak about mediation in administrative justice. Is that a step towards building the confidence on the part of the citizens, or is that Trojan horse that will invade the system and will destroy it and destroy certain principles? We're not speaking about those things, about those things in the civil law, but in administrative law they are very important. So we can look at the principles and challenges, and on the basis of the discussion try to answer why we have selected this model that is starting from the third stage, then move to the second stage, and maybe finally we'll receive the first stage. One of the things is that in mediation the goal is to ensure the balance between the interests. In administrative justice, we have this balance between the capacities of the parties to the dispute, because the administrative, the citizen seems to be a little bit subordinated to administrative institutions. Also, the rule of law principle establishes that certain institutions can operate only within the framework of the law, what is provided by the legislators. So they cannot abuse the law. So we have some kind of structure, and the question how to introduce mediation in that case, like to ensure some equality between the parties and reconcile it with the essence of the administrative law. How to obligate the public interest institutions to act in the interest of the citizens. So the next issue is the principle of confidentiality. Any subject of administrative institutions will always question the possibility of mediation due to the insecurity of mediation, because they need to receive information, and the citizens have to receive information about the activities of the institution. Because one of the basic principles of good administration is the possibility to access of information, so that the institution has to treat every citizen equally. So if you don't know what can be achieved by way of mediation, so naturally there is the question how to achieve that equality, so that possible reservations granted or privileges granted with respect of one person, so the person, the other one has to know that maybe he is entitled to the same privileges. So we see here some kind of disbalance in speaking about the public interest. Certain issues cannot be resolved by mediation due to confidentiality concerns. Let's say, can you imagine a situation concerning protected territories in construction cases? So hardly such cases can be resolved by mediation and at the same time ensuring confidentiality. So we have some kind of risks and threats, and that comes from the very essence of administrative law, because that is the state that operates for the benefit of all citizens. That is not the dispute between two people. And this public interest is a very important factor here. It's more or less prominent. So the challenge is how to bring those two things together. I might say that in some administrative cases that is not a problem, but only in some cases only. Another thing is that we say that parties can agree, they are equal, they can pass the decision, and there is a question whether such decision or such agreement is valid at all, because some institutions have the very limited discretion to take decisions. So, let's say, if an institution can take a decision only to approve or disapprove, that is yes or no, so in some cases it doesn't have that discretion. That does not prevent them to apply mediation in the areas where an institution has the right of discretion. There are many areas where, just according to the law, the public administration institution can choose one of 4 decisions without coordinating, without agreeing that with the other party, because he would just take the advantage of possibilities provided for in the law. Of course, such decision can be later on appealed. Later on, if this decision is being appealed, or maybe it can be explained with the help of the mediator that this decision was quite reasonable and the public administration institution could continue working in that area. So there are some areas where public interest institutions have quite extensive discretion. So then another thing is the principle of equality also concerns the situation as to how the other party has to find out and to learn about the decision. So, is it possible by way of mediation to agree a decision if that decision concerns a third party? Let's say neighbors of a land plot or something that, let's say, a neighbor saw the decision of the administrative institution. They are happy with the decision concerning that their rights will be protected. But let's say there is in mediation, there are other parties involved, and that is a risk of another legal dispute. The issue of building precedent is also important when many institutions apply to, or people apply to a public administration institution. So in this case, if we need to build a precedent, it's important to assess whether the dispute is eligible for mediation. All those challenges can be overcome if we provide which of the disputes are eligible for mediation and which disputes have to be excluded, because it is not in all cases that we can take advantage of the mediation based on the results of the study conducted by European Commission. Lithuania looks quite good because we have the judicial mediation.
non-existent.
Because in many other countries, this mediation, judicial mediation is not existent. Also, if there is international guidelines about mediation, would that encourage countries to apply mediation to a wider extent? The answer from most of the countries was no, that would not encourage. But still, we have some very good examples from the Netherlands, from Germany, where mediation is successfully applied in administrative disputes. We have in Lithuania also some very successful examples of application of mediation in administrative cases. In general, Lithuania looks very favorably towards mediation. The judges are very proactive, so they disclose all the information about mediation cases with the courts. In the case, mostly for research purposes. So, problem issues, just to sum up, one of them is the difficulty to receive data. Currently, we don't have any statistics or empirical studies to be used by researchers as to which model is most reliable. So we don't have the data flow. So maybe one of the principal area is to develop this kind of database. Another thing is the model selected by Lithuania. As you remember, we started from the third stage, then moved to the second, and we can move to the first. So this model was assessed rather favorably. But the experience in most countries has shown that this mediation in those three stages can be applied, and the level of satisfaction with our mediation in administrative cases has been assessed at 80% satisfaction. So what did we do? We created some kind of supply. We trained judges to be mediators, but another thing is that demand in mediation in administrative disputes. In Germany, there have been some studies assessing the application of mediation in administrative cases, which shows that the weak part is the public administration institutions, because they didn't know whether they can apply mediation. The other party of the dispute normally want mediation, and that is also approved by judges. But we have a problem, demand problem, and the public administration institutions in most countries are very reluctant to engage in mediation. In Germany, the institutions have said that it will take years to change this mentality of institutions to understand that mediation is a good thing. So that means certain challenges in Lithuania, and this introducing mediation in Lithuanian institutions is a task for the future. Some other speakers spoke that it's not a good thing to propose mediation, but that is not true in administrative case. maybe it would be possible to create some kind of algorithm for decision makers so that everybody could understand when mediation is possible, because such algorithms exist in certain areas, let's say text disputes. At the same time, ensuring full transparency, because parties would be aware when mediation is possible. And of course, the discussion can be broader, because mediation can be also practiced not only by judges and researchers, but also certain institutions such as the public audit office or special investigation services, because often we hear opinion that parties refuse to engage in mediation because they are not sure how other regulatory institutions will treat the decision. The transparency requirement must be met, but we could draw up some kind of guideline which would be helpful to public administration entity, not to be afraid that his decision can be sanctioned or revoked.
Vieną principą, apie kurį mes galėtumėm kalbėti ir kaip gairė tokia ateičiai, tai viešo administravimo įstatyme mes turime tokį principą naujovių ir atvirumo permainos. Šis principas reiškia, kad viešo administravimo subjektas turi ieškoti naujų ir veiksmingų būdų, kaip geriau spręsti problemas, iškylančias vykdant viešo administravimą, taip pat nuolant tobulinti veiklą, taikant pažangiausius metodus, modelius, technologijas, priemonės ar gerosios praktikos
Here we have space for mediation, and if we thank you so much. If you have any questions, please be free to ask them. Yes, we do have questions, and maybe let's have a very quick question answer session. We have 5 in total, and I will ask 3 questions, and if you can, please be very, very short in answering them. First of all, who, in your opinion, should decide if the dispute is eligible for mediation or not? A decision maker is, in essence, a mediator. Only a decision maker can decide whether it's eligible for mediation.
Tai teisėjui arba administracinių ginčių komisijos nariui gali kilti nebent klausimas, galbūt verta jį perduoti.
There can be questions whether it's worth referring it to the mediation, but then they can be consulted with other specialists.
Why
is that it's only judges that could mediate in administrative disputes? Well, it's not the case. It's only because it's not free of charge. If it's free of charge, then it wouldn't be only the judge. But as of 2021, there will be a list people can choose from if they pay some fees. The third question, let's imagine that applicants want to take part in mediation. What are the main factors that would make the entities agree to take part in mediation? Well, it's that the most difficult thing. Maybe that's a prospect of career, or maybe a very wide attitude or very wide approach to serving for the country. Today we have no other motivational factors, unless that would be a general understanding that it's beneficial for the state. Thank you, Salia, for such a wonderful presentation and such good answers. Maybe we can discuss mediation with you in the panel discussion, and while we are preparing for the panel discussion, we will hear another presentation for foreign presentation. I want to introduce Mike Smith, and for that I want to say that mediators are very progressive people. They are improving, they improve, they learn, they self-educate on a regular basis. And it comes with no surprise that we invited Mike Smith from the Netherlands with a very interesting presentation and innovative approach to mediation. That's a systemic approach to mediation.
This is Mike Smith. We are glad to have you here in our conference. And as long as you are giving the final presentation, we hope that it will give us a lot of thoughts and ideas to think about. And I have already said that it is really something new, especially in Lithuania, the systemic approach in mediation. And as I know, you are the specialist, expert in that matter, and even have written a book about systemic approach to mediation. So you are very welcome to present your presentation and give us all your thoughts. Thank you.
Thank you so much for the opportunity. Let me see if I can share my screen in a bit, but maybe first introduce myself, because I used to be a lawyer. I was trained in law and worked as a lawyer for the Dutch government for many years. But now for, I guess, more than 10 years, I work as a trainer and coach, independent, working from the philosophy of systemic work. And I wrote a book about it. Also a lecturer of the Netherlands Business Academy, that is of Jan van Swieten. And there I give the systemic approach in mediation. So I love to tell you a bit more about it and start to share my screen. I hope that it is visible for you at the moment. Yes, I guess it is, because I can see it also here on my screen. So let me share the outlines of my presentation. I will first share a bit about the origin of the book and the training systemic approach, then tell you about what systems are and the systemic principles, what it means to look from a systemic perspective, and especially in mediation, where I distinguish dynamics on 3 levels. And then I tell you a bit more about the destination and the master of mediation that Jan van Swieten also told you about, to conclude about the success and costs of systemic approach in mediation. So let me first explain a bit about the origin. Here's a picture of the books that I wrote. And in systemic work, origin is a very important aspect. Where are you from? Or how and with what purpose did something start? Let me first explain a bit about the origin of the program. When I came to know about systemic work more than 10 years ago, a whole new world revealed itself to me. I learned about how people relate and how one can encounter unsolved inner conflicts in relationships with other people. I wanted to share that insight and wrote my first book, Loss, in 2014, which is a book about coping with divorce. Besides that, I developed a program for rebuilding one's life after divorce and started to guide divorcees and people with relationship problems. And one day I met a mediator who read my book and knew about the program, and she requested me to teach part of the program to mediators. So that was when I first started training systemic work to mediators. As a mediator, there is one important aim. You want to resolve the conflict for both parties in the most optimal way. Most of the time that works out fine, but there are times, however, that you can't seem to get a grasp on it, or suddenly the dispute flares up again. Evidently, there's more to it than meets the eye. For professionals who work with people, it is important to know about the distinction between the upper current and the undercurrent, what is on the surface and what lies beneath. The upper current is what you can hear and see, and the undercurrent deals with subconscious driving forces from the systems of which one is part. The undercurrent determines what happens in the upper current. So it is very important to also expose what is of influence in the undercurrent to reach an in-depth solution. What is a system? A system is not always visible, but present network of relationships and interactions. Every one of us participates in several systems, starting in one's family system of origin, and then we enter other systems that we call organizational or task systems, like the football club, your school, work, or the office. Interaction between people is like a system with communicating vessels. Behavioral patterns work within a circular system and determine the dynamics within it. When one person undertakes an action, it has an effect on how another person reacts within that system, and vice versa. Bert Hellinger is the founder of systemic work and family constellations. And a constellation visualizes the interaction between people in a system or the dynamics between them and their patterns. By literally placing members of the system or certain suspects in relation to each other. This is done in a room using representatives. These are people who represent members or elements of the system. And in mediation, you have no representative people available, but there you can make a constellation with symbols, like on the picture here. The figurines are shown here, can be used on a table constellation. The straight figurines represent masculinity, and the triangular ones, femininity. The greatest common characteristic of systems is that they tend to want to survive. Systems want to continue functioning and have a self-regulating capacity for it in the undercurrent. That self-regulating ability often determines the dynamics in a system. There are 4 principles that make and keep a system healthy and strong. If something within a system is not going well, it is advisable to look at the state of these 4 systemic principles. The first systemic principle is the principle of order. It's like a systemic ranking. In families, it is based on generations or hierarchy, seniority, and in organizations, it's based on hierarchy or functional structure. Is everybody standing in the place that is there for them? Members inhabiting their proper position in the order of the system is of great importance to the extent of which a system continues to function. But if there is someone missing, the system ensures that someone else in the system takes up that position so the system can continue to exist, though not very strong, and it will influence the dynamics in the system. The second systemic principle is the principle of balance between giving and taking, exchange. Between members of the system, there should be a proper balance between giving and taking. Most people possess a kind of internal sensor or sensitivity to that flow. If this balance is upset for a longer period of time, or if the exchange is stationary, it will start to be frustrating. There is no equal balance, though, between parents and children, or teachers and pupils. They give so that the children will forward it in their lives. The third principle is the right to a place in the system. It goes about inclusion and exclusion. Everyone who has ever belonged to the system has a place. This can't be ignored, pushed away, or forgotten. If that happens, it will determine the dynamics and lead to disruptions, blockages, or conflicts that weaken the system as a whole. Every system strives to be complete. Not only individuals can be excluded, but also events or feelings. The fourth and last systemic principle is destination and finiteness. Organizational systems, other than family systems, can come to an end. The journey from origin to destination can be completed, the task accomplished. Our tendency is to continue for as long as possible and not to give up. But if the destination has already been reached and the system is being continued regardless, a system is no longer powerful and symptoms can arise, such as lack of energy or reduced decisiveness. Looking from a systemic perspective means looking at people within the context of the systems they are part of, as well as the history of those systems. The family of origin being the first one. It means that you have an eye for the invisible interactions between people and events. It also means knowing that patterns are often created by the system as a solution to a problem and can be passed on to a next generation. So it's advisable to find out for which problem they might signify a solution. For example, when an older sister is taking care of the younger children in a family because their mother has a long-term illness. Becoming aware of the pattern, recognizing its function for the system, is the first step towards breaking a pattern. In mediation, at the mediation table, several systems suddenly come together. Each of these systems bring a certain dynamic to the table, and those dynamics affect what happens in the undercurrent. As a mediator, it pays attention to be aware of it. In order to explore what determines the undercurrent, it is necessary to unravel the systems and their effects at the table. In order to do so, I distinguish the dynamics of each individual's family system on three levels. The family dynamics on the individual level, the dynamics between clients, and the dynamics between clients and mediator. And I will tell a bit more about those levels. The first level, family dynamics on the individual level, influence each party on the mediation table. We all start our lives in our family, our system of origin. From our parents and ancestors, we not only received our DNA, but also our view of facing the world, our values and beliefs. The effect of traumata can even be forwarded for 7 generations on. Our place in our family of origin gives us a basis of how we perceive situations. What did you learn best in your system of origin? What was not that much developed? And how is that system of origin still influencing each person? This gift of what I call your gift and challenge originated from your system of origin, determines your way of facing life and also the choice of partner or work. It's a kind of blueprint for life. For instance, if your parents were busy working, you may have developed the gift of being independent, but to merge with a partner can then be a challenge. The second level is about the dynamics between clients, the collusion in the relationship. How do patterns of two partners interconnect? The pattern of the one usually fits the one of the other perfectly. It's like an unwritten premarital contract. Adventurous man seeks steady woman to come home to. Or in business, people manager looks for a technical supporter. The interconnecting pattern can be complementary or the same. Partners somehow recognize each other, just like in their family, or surprisingly different. A partner can be excellent practicing material to work on your challenge, but not all couples take the opportunity to do so. So then when major life events occur, they each end up on their own side, disliking about the other what first was attractive. So then the adventurous man is suddenly perceived as irresponsible. Do you already recognize some of these patterns yourself? Conflicts are often unresolved inner conflicts manifesting outwardly, as I quote Bill van Sieverden, a holistic lawyer. The interconnection of patterns can also be seen in the conflict of divorce at the mediation table. If that is not addressed, chances are that new conflicts arise even after the divorce papers are signed. The third level of dynamics is the dynamics between the clients and the mediator. What do you as a mediator bring to the table, and how does that influence your efficiency as a conflict solver? Sometimes you can get drawn into the dynamics of the conflict and of the clients because systems interchange. If you think you have to empower one of the clients, for instance, Who did you have to empower in your system of origin? So it's good to know your own set of gifts and challenges and how they play a role in your life and work. And besides the systems of origin, what other systems of which clients and you yourself are part of in the present that invisibly participate at the mediation table. So once you see this picture and come to notice all the systems' influences, it can become quite crowded at the mediation table. Besides origin, as I said, destination is also of importance in a task system. So the destination of my book and the training systemic approach in mediation is to reach many mediators and to help them reach sustainable results. In the book, in the Master of Mediation, you learn about systems and their systemic principles, more about what I told you before, common patterns and collusions, communication patterns and emotion that you can encounter at the mediation table. You can get a roadmap and practical examples, and not only in divorce, but also labor disputes between two people and neighbor conflicts. You get suggestions for self-examination. And the book will be available as of next week through bol.com or Amazon. So I can say that using the systemic approach is successful and that it can lead to reaching more sustainable results. Although we don't have figures yet about it, because it's also a new approach in mediation in the Netherlands. Not much research has done about it. But I know that mediators, very experienced mediators, say that using the systemic approach leads to even quicker results because it exposes the core and the root of the conflict. It will cost you something, however, because it will cost the investment of learning how to apply the systemic approach by the mediator. And sometimes it may seem like taking a systemic detour to get to that root of the problem. And then it will also take a bit more time or even more costs or expensive for the clients. But my experience also, and that of the other mediators, is that in the end it will save time, energy, and it will also prevent the risk of reigniting the flame of the conflict. So I advise mediators to be aware of the functioning systemic influence on all three levels and to ask questions that lead to exposing the patterns of the system. Be curious and non-judgmental because patterns exist as a solution for a problem in the system in order to be able to exist. I also advise mediators to explore their own systemic background and the influence so that they can become more effective in mediation and conflict resolution and together reach sustainable solutions. I thank you so much for the opportunity, for the translation and your attention. If you want to know more, feel free to contact me.
Thank you, dear Maike, for presenting your ideas, your thoughts, and your book. Definitely, it will be very popular. I just have a small question before we go to the panel discussion. What brought you to think about mediation process through this systematic approach? Because usually when mediator starts to work with the dispute, it looks like a complete chaos. And yes, it would be good to have a system, but not always it's possible. So what was incentive for you to start looking at mediation through this systemic approach?
Well, like I said, it was my personal experience that looking at my own system taught me a lot about how I interconnect with other people and how every one of us has a systemic influence that we bring along in the conflict, but also in relationships that flow well. So I was also brought to bringing this systemic influence in the mediation by a mediator because she thought that it could help them also reaching the clients, bringing them more awareness about their own part in the conflict to be able to really go to the root of the conflict and try to solve that. So is that an answer to your question?
Yes, I guess yes. So
Yeah.
thank you so much for your input, and we are saying goodbye to you and move back to Vilnius again.
Thank you so much.
Ir aš perduodu žodį Artūrui.
Taip, tai visiems taip pat savo vardu noriu padėkoti pranešėjams.
On my behalf, I want to thank all speakers, and once more I want to thank the mediation experts, Egidijus, Gintautas and Salvija, who kindly agreed to stay here with us and to discuss mediation, our panel discussion for some half an hour.
The presentation before lunch said that each mediation process is a very undefined, unspecified situation. It's kind of jazz. It's always a challenge. It's, you never know what to expect in the next minute. So we're exactly going to apply this model, this approach for this discussion, because we don't know what kind of questions we can receive. We are limited in time, so I'm absolutely clear that you have a chance to share your experiences and insights. So we have three pillars. So that is civil justice, administrative justice, and criminal justice. So maybe each of you want to add something that you did not manage to convey during your presentations. Maybe you have some afterthought. So the essential thoughts, in my opinion, is concerns the idea of mediation. So what is that process about? In my opinion, mediation is not concerning the settlement of dispute. When people and mediators understand that, I believe mediation will have a little bit different face and maybe some predictability. Because mediation, first of all, is the changing of approach towards the conflict and maybe changing of approach towards oneself. Understanding that maybe you can understand and find other ways of resolving a conflict. People should not having come to a mediation session, expect that conflict will be resolved in no time. So maybe the first thing that people would have to understand is they need just to come to a table together and start talking. So that is the main idea that I would believe is a kernel for the success of mediation. Yeah, the questions that came from the audience were really meaningful and good, whether the issue is eligible for mediation or not, and also your commentary think about mediation in family relations or criminal justice. In this case, we have to understand the specificity of criminal justice. So those are the most important things that often are discussed in criminal justice. First of all is the presumption of innocence. So there can be several approaches. Maybe some who hold a more flexible stance believe that the person has to plead guilty. Maybe if he stole something, so maybe he stole something unimportant. another opinion is, so why would the state want the victim to participate in the process? So there are different opinions. So I would like to say that when we speak about domestic violence, this concept of victim becomes even more important and more relevant and sensitive, because maybe we place the victim in even more humiliating position. And mediation would, what would the mediator do? Maybe suggest that the victim and the perpetrator should discuss and maybe to agree. So what I learned from my experience in Germany was that in one case people decided that they wanted to divorce, but they started speaking that there's things like money, there's some assets, property, children, so they understand they need to talk, and maybe court is not the best arena for talking, so maybe mediation is better arrangement here. I would like to ask another question, that prosecutors very often say that we cannot apply mediation for a single reason, because it's not regulated. And they say just regulate it and we'll start applying it. No, not really. Not really. Because even the speakers who spoke from Italy and from the Netherlands said that mediation was just launched without any regulatory
Tai čia tas mūsų, iš Baltarusijos kolegė irgi pranešimo, sako priešingai. Įstatymą turim, nieks nevyksta. Tai va čia, man atrodo, mes labai nepagristai tikim įstatymo galia, kuri neva turėtų veikti pati savaime.
Speaker from Belarus mentioned that first they adopted the law and started applying. Maybe it is quite unreasonable that we believe so much in the healing effect of law. Maybe because nowadays we can do a lot of other things even without any strict regulatory framework. I don't have much knowledge about mediation, but I remember now the case when I was some 20 years ago was having an internship session in Germany. There was a rape case and the court was adjourned
and dviejų žaginimo epizodų prokuratūra atsisako.
And then the prosecutor and the defendant and the counsel for defense returned and said that two cases of rape were dismissed. So could you comment on this kind of instance, and definitely there is some kind of cultural differences. Maybe you comment that as you are so knowledgeable in German law. The general principle is that mediation should not be applied in very severe cases, because mediation is in itself is a very violent intervention in the case. So if the parties can reconcile, can settle their disputes, so that is one story. But only we believe that more severe cases should be addressed to mediation. So the prosecutor perhaps will be looking at the situation, but I would say that the rape law is more marginal case, because the harm done and the negative experience are so painful that perhaps it would be difficult to
būtent tų seksualinių nusikaltimų atvejais, antrinės viktimizacijos, tas rizika.
So, in case of sexual crimes, secondary or repeated offense, risk is
Reiškia,
always
mediacijai
high.
kaip tik
Taip, jeigu jie taip atsargiai, jautriai darant ir aš labai žiūrint, sakau, situaciją, kas tai buvo.
Anyway, it all depends on the case-by-case basis, depending on the relation between the perpetrator and the victim. And this perhaps the secondary victimization perhaps is less probable, and perhaps the victim would be feeling less humiliated than in case of judicial litigation.
Bet aš netikiu, kad jūs viską pasakėte.
I don't believe that the speaker on administrative justice has said all she wanted to say, so you are very much welcome. You are very much welcome to add.
Tai 15 minučių žinoma riboja labai mūsų tą
Of course, I could speak for much more, because as a teacher I'm used to speaking to about 1 hour and a half. But maybe my idea was the following: that what is the essence of mediation? That maybe some things cannot be resolved in courts. The interesting thing from the foreign practice, from insights from foreign institutions, is that even if you don't decide, don't reach the agreement or final solution, mediation is still a good thing, because that strengthens the feeling that there is some kind of institutional approach. Even in one case, the person, the feedback from the person was
Tai yra pažodžiui būtų, kad su pareiškėju pirmą kartą buvo pasikalbėta.
He said that he was happy to have the mediation because he felt that it was the first time that somebody was speaking to him. And results of the studies have shown that in most cases mediation is very favorably accepted by parties to administrative disputes, not only in the cases where the positive decision was taken, but even 70% of participants were happy with mediation because they were happy with the procedure itself. So that's why I wanted to speak about it, because I believe that many parties would find it attractive, but what we need to do, we need to move to the first pillar, that is the introduction of technical opportunities, just to arrange that the party could be listened to and could be heard, and that would contribute to social justice. Polish and German scientists have claimed that they have this arrangement. They have mediation opportunity in public administration areas, and they believe that there would be a good idea to have this kind of forum for the parties to come and make their ideas known. Also, the scientists said that they kind of respond to the new phenomenon that is a transformation of the administrative system. We are not here to speak about hierarchy, because the civil servant is a servant to the public, so he is at the very bottom of the hierarchy. And a very good example is from France, which I had numerous opportunities to see the arrangement in which the judges in administrative cases are not wearing their gowns. They come dressed regularly, and they are on the same level as the public, because they are not above, they are not superior to the representatives of the public. And I received a question from my colleague from Vilnius University. So this kind of anti-university discussion about the possibility of mediation in text disputes. Actually, I needed to, I wanted to talk about that. Just speaking whether the mediation is possible at all, and on the level of tax dispute, it is still not existent. Interestingly, tax specialists speak that there is a possibility for a settlement agreement. They apply all kind of reconciliation forms, because there is, if the evidence is not sufficient, there is a possibility to have an amicable agreement with the tax administration, and that is provided in the law, but that is not mediation, that is a kind of statutory provision, because there is no mediator involved in that, but the possibilities are present, they can be taken advantage of. The next stage, starting from January 1st, we'll have the mediation in administrative dispute commissions, but in the tax dispute commission is not included in this beneficiaries of the project, and I don't really know why, because I read all the explanatory notes about the project. And I don't know why, because tax disputes are considered kind of very specialized. That's why they were not included, but that is not mutually exclusive. I believe that tax dispute commission should be included. Also, there was a question regarding the legal regulation. So we believe that the argument was that mediation is much more easy to implement in administrative disputes, but not in tax disputes. So I don't fully agree with that argument, and in my opinion, mediation is still can be scaled up in terms of its application, and should be introduced at the pre-trial level through the Administrative Dispute Commission and assess it as a pilot project. If we see it successful, it could be then further expanded. Can we assess right now whether it's going to be a success? So that would be, we could refer to a good practice example in Germany. When in Germany, when they started applying mediation in courts, in judicial system, there was no regulation. They wanted to try as a pilot project. They engaged several university researchers who were observing the process. They were not mediators, they were work gratis, but after each mediation, each parties participating in the process were interviewed, trying to find out why the process was successful or whether there were reasons to fail, and eventually they produced a huge report which was then referred to for the amendments of the law. So, we are going to implement a project. We'll look excellent in the background of other companies. But I would suggest that the project should be considered as a pilot project, so to collect the data and maybe to think in the future to which areas such projects this arrangement, mediation arrangement, could be expanded to other areas. So I still believe that we'll be able to go that path.
Tai jūs, mokslininkai, gal jau turit kažkokius tyrimus, ar tyrėt galbūt jau tuos pirmosius žingsnius teisminės mediacijos administraciniuose ginčuose, ar dar neturite?
Tokių labai detalių kažko neturime, mes matom atvejus, tiesiog jų nėra daug dabar per 19 metus, pavyzdžiui, berods Vilniaus apygardos administracinėme teisme buvo 5 atvejai, kai buvo perduotos mediacijos, tai jų iš esmės dar kaip ir nėra daug, mes tik matome irgi iš esamos informacijos, kad pavyzdžiui, viena mediacija nutrūko todėl, kad būtent valstybės institucijas pasitraukė. Na ir matom, kokios ginčių rūšis yra. Tai apibendrinimui dar medžiagos mažoka, žinoma, kokie atvejai 4 jau 2020, o dabar turbūt daugėja, bet šitoje vietoje iš tikrųjų būtų tikrai labai noras pažiūrėti giliau ir ką mes galėtumėm kaip padėti kartu susėdę su praktikais ir mokslininkais, tai tikrai išdidinti tas gaires ir sritis ir gerasias praktikas, kur mes galim plėtoti mediaciją. Aprašyk situaciją, nevardinant ten šalių, bet kokiu atveju buvo
and good practices and to see which were the cases when mediation would have been successful. Maybe it would be tax disputes, higher education cases, which are very popular, let's say when agreements are made abroad and mediation takes place. And now we are only told that mediation is possible only when the settlement agreement is in place. Otherwise, they are possible when it does not infringe the public interest. And it also relates to regulatory legal acts or elections. So we don't have such fields where mediation would be really successful and efficient. So every sector should have a list of good practices with an in-depth analysis. We don't have such in place, and we should come to a shorter view. So science has really good opportunities here to act. I want to ask Gintautą, do you have any concepts, let's say, in developing mediation in criminal law? You had it drafted earlier. Maybe you've taken some steps, some actual steps. No, I haven't heard of it. But as I said, it's somehow attached to probation when mediators are employed, and there were some 100 mediators trained in Norway, but mediation which is attached after the verdict, after the judgment. So Norwegian practice shows when mediators go to prisons and then they would be offered an opportunity to review the situation. But when mediation is attached to probation or judgment, these are very rare cases, but everything must happen until passing the judgment, not after it. So as far as I know, in this field there are no considerations, neither practical nor theoretical ones. If you think that the breakthrough is needed, where would you make it? I believe we should have a mediator, as it is established in Article 38 of Criminal Code. When it comes to a process, when it comes to a mediator, when we have an actual discussion of what happened, when we have the actual consideration, assessments of psychological fears, overcoming the fears, then the value is really of high quality one. And again, you cannot act on your own. We need some initiatives in this particular field, which must be then be funded. We must have quality standards, and if we really want to do that, maybe we can, but still. There was one case I heard, there was one criminal case which was referred to mediation by a judge. Have you heard of that case?
Nesusidūrėte?
No, haven't heard of mediation, but the example is really great because it's not prohibited. The prosecutors are not forbidden from referring cases to mediation. We must understand that. You can take some radical, really brave actions, and if they are justified, they will not be unlawful. So we need and we lack this freedom of taking actions, and we go the easiest ways. We have one more question from the audience. Maybe I can do that now. It would be
Ar mediacija galėtų būti taikoma kartu su baudžiamuoju įsakymu?
to answer it. Could be mediation applied together with the criminal judgment?
Galbūt galėtų pasibaigti taip, tarkim, nes baudžiamas įsakymas dažniausiai
It could
būna
be
vėlgi tokie
finished
paprasti
like
atvejai.
this. These
Mes mediaciją
are
žiūrim
very
kaip
simple
gana,
cases.
sakau,
When we
tokią
treat
vidutinio
mediation
sunkumo intervenciją,
like
tada klausimas,
moderate
kam dar
severity
ją kabinti
intervention,
šalia kažko tai
then the answer is why we should attach it to something else. But maybe it's possible
Dar norėčiau
theoretically.
paklausti
I would
mediatoriaus,
also like to ask
iš diskusijos dalyvių,
a
neskaitant
mediator.
moderatorių, tai Egidijus yra kartu mediatorius, taip?
Egidius, if I'm not mistaken,
Rimantas
you are a
Simaitis
mediator as
kalbėjo
well.
apie privalomą mediaciją,
Rimantas Simaitis
mokamą,
was
nemokamą mediaciją,
talking of
o
mandatory
du iš esmės klausimai
mediation,
pakankamai
mediation
praktiški.
free of charge,
Rimanto
and one that
Simaičio
must be paid
jisai tą nuomonę
for. And
išsako,
he
manymu,
has been
negali būti
expressing
visiškai
that
nemokamos
opinion for a
mediacijos,
very long
nes
time
nors
now.
kiek žmonės turi pajausti, kad susimoka už paslaugą, priešingų atveju jos
He says
nevertina.
that people
Ir čia
must
ne vien tik
pay
tai
for
Rimanto nuomonė,
mediation
čia
at least
yra
a minimum
kiekvieną
fee,
kartą.
otherwise
Tai
they don't
jūsų
believe it
kokia
will be
nuomonė?
effective.
Ir dėl
What do you
privalomos,
think?
mes
What's
šiandien
your
turėjom Italijos
opinion?
pranešimą,
And what
ir
about
ten buvo
mandatory
visas sąrašas
mediation? We
privalomosios
had a
mediacijos
presentation
bylų
from Italy,
civiliniuose
and there was an
Net
exhaustive
dabar
list
nuskambėjo
of
ginčai kilę iš pandemijos
mandatory
situacijos.
mediation
Tai čia negali būti
cases
ginčas,
and
čia
topics.
tiesiog priežastis.
It even included
Tai
the
irgi
pandemic.
perdodama mediacijai privalomąja tvarka.
And all these
Apskritai
cases
reikėtų
were referred
plėsti
to
mums
mediation in a
privalomos
mandatory manner.
bylų
What do you
sąrašą.
think
Taip,
about it? Do you
Taip,
think we
čia
should expand the list
diskusija pakankamai
of
gili.
cases for
Italijos,
mandatory mediation?
atvejis jisai yra
Well, yes, the case of
išskirtinis
Italy
tuo, kad
is
Italai
an exclusive
dar
one because
2010 metais
it was
priėmė
2010
tokį keistą
when Italy
poįstatyminį
adopted
aktą, kuris po to buvo pripažintas
a secondary legal
prieštaraujantis
act
konstitucijai.
which was recognized
Bet jie
as being in
suformulavo
conflict
tokią
with the
gerąją
constitution,
praktiką. Čia galbūt
but
apie
they
tai, ką
formed a
vat
good
čia diskutuojam
practice,
apie tą,
which we are discussing
įstatymo
right now.
absoliutinimą ir galvojimą,
And
kad
when
jeigu
we
yra
make the
įstatymas,
law
tai būtinai
absolute,
kažkas
and
turi
when we
veikti,
think that
tai
if there is a
Italai
law,
jie
something must
padarė
work,
privalomą mediaciją praktiškai
that
absoliučiai visur.
country in this case
Visose
made
srityse.
mediation mandatory in
poros
all
metų
cases.
Konstitucinis teismas pasakė,
2
kad
years
taip negalima
later, the
daryti.
Constitutional
Nu,
Court
vis tiek.
said that was
Bet jau
not
praėjo daug
okay,
laiko, tie
but
porą metų, kai
still,
buvo mediacija privaloma visose srityse.
those
Ir ten
2
jau ką tas
years when
Konstitucinis
mediation was
teismas
mandatory
pasakė,
in
ten
all
galima,
cases,
negalima, kitaip turėtų būti. Jau visuomeniai tas nebebuvo įdomu, nes visuomenė jau įprato.
very interesting to society because
kad ir koks
it became
bebūtų
quite
ginčas,
usual
jie tiesiog
because
privalomai
people
turi
knew it
dalyvauti
doesn't matter
mediacijoje,
what
po
kind
to
of
jie,
dispute you have, still you
sakykime,
will have to
gali ten
undergo
spręsti, ar jie
mediation.
toliau bylinėsis, ar tenais
And
teismas, ar
only
ne. Čia
then
gal su tuo susijęs ir
the decision
klausimas
will be made
dėl
whether the
atlygio,
case is
tai
referred to the
bet
court
kuriuo
or
atveju
not.
ta mediacija, jinai
Fee is another matter.
nemokama, tai mes žengiam pirmus žingsnius.
I don't know whether it should
Skatinam,
be
nes
free
yra
of
vienas
charge or
iš
should be
skatinimo
paid
priemonių, kad
for,
žmonės pradėtų
because that's
naudotis arba bent
means of
pabandytų verslas, visuomenės atstovai,
incentives for
sakykime, kad jie
people, for
pabandytų
businesses to try it
pasinaudoti
out,
mediacija,
to
už tai jiems
use
sudaroma
mediation.
galimybė,
Therefore,
nors
they
ir
are given an
privalomai,
opportunity
bet nemokamai,
to
nes tas
undergo
privalomumas, jis irgi
mediation,
kertasi su
even if
savanoriškumo
it is
principu,
mandatory,
kad
but it
mediacija
is
turi
free
ateit,
of
bet
charge.
jeigu tau nieko nekainuoja, tu tenai dalyvauji,
Again,
tiesiog atėjai
if you
ir automatiškai gali
go
išeiti,
to the
ne,
mediation,
tai
and
pasekmių
if you
neigiamų,
can
nu, tai tu
leave
kaip ir
it at any
nėra tokio,
stage
kad
you want
tave
with
kažkas
no
privalomai jau būtinai
consequences, then you will not feel this sense of it being mandatory. And we can see different practices, let's say in the USA or other countries, when, let's say, it's a period of 120 days for mandatory mediation in healthcare sector. And other countries also say that mediation must be mandatory in certain fields. And in certain countries, people must pay for it, otherwise they do not value mediation. And mediation is provided as a service, and when you receive a service, you must pay for it to feel the result you get and to feel its value. And there was a discussion with the mediators in Austria during the symposium. They said that they have been raising the hourly rates for people to reach an agreement as fast as they can. That's why they were increasing their fees, because people were encouraged to make a settlement agreement as fast as they can. And this took a major part of our discussion. At first, we were discussing the necessity to have the regulation of mediation. Now, we're saying that we can regulate it, we can apply it, it doesn't matter whether it's criminal law or some other fields. If there's no conciliation, if people cannot be exempt from criminal liability and so on. And one example, let's say, my personal example, I was asked why it cannot be subject to mediation. There was one road accident and the victim had no claims. The judge said, well, I understand that everyone is happy here, but still you will have to pay a fine. And then why should someone pay a fine when no one is injured, everyone is okay with everyone? We have a judge employed, a secretary employed, all the mechanism employed, and the fine was only 30 euros. It was neither beneficial for the budget nor for someone else, or nor justice. It was just a matter of attitude. That's it. Yes, and that answers one more question. Could the judges be court mediators? Because the function of the court is to administer justice. So at the very first stage, at the initial stage, we should change the culture of litigation, the culture as such in general, when it comes to the courts. But we used to have psychologists, assistants, notaries who could act as mediators, and now it's judges who need to be the mediators. And it doesn't matter who it is, a judge or someone else, still the essence is in the process itself. Well, I want to respond. There was one more case relating to the role of judges as mediators. At first, they were called judges mediators, but after then, they were in Germany only peace judges or conciliation judges. They are no longer called mediators. They have no right as such. And one more observation from the proceedings or mediation processes. It would be very interesting to see how the mediation processes are carried out here in Lithuania. It's very interesting to see how the judges, let's say, leave their role as a judge and they become mediators. And it's very interesting to say to see when the judges say, well, as a judge, I would like this and that, but as a mediator, I would say that this must be like this or like that. And everyone is very happy about such episodes, because here a human or a specialist is more active, and then they always are very positively treated. And we are running out of time. One last question for you all. Is it a myth that courts are very resistant to mediation? Is it a reality, or is it true or not? Giedrė, what do you think? You're a judge, you're a mediator. Well, I don't know. I wouldn't say that courts are resistant to mediation. The courts themselves, as institutions, are not resistant when it comes to judges. Maybe not in all cases. Maybe they don't think that all cases are prospective. But very often they ask questions about mediation. I happen to be in training, and let's say I happen to hear a lot of times when the judges say, well, you have a mediator, when you undergo the mediation process. So they are really trying to use the measures to make mediation work, and I think they are quite active in family disputes. Even after the parties undergo the mandatory pre-trial procedure, and then I heard before the court, I heard from the judges recommending to repeatedly undergo mediation. So I wouldn't say that courts are resistant. That's a very good question. I think we would need research to be conducted. Maybe we need some scientific justification or reasoning. Courts shouldn't be resistant to mediation because the workload, the caseload is huge. I think every court would be happy to reduce the workload. And there was some study carried out some 30 years ago when the judges said that, well, we don't have that true justice administered. So in that case, I believe the judges would see a more advanced dispute resolution in mediation. So I don't think that they should be resistant. Well, when it comes to administrative justice, I talk to many people, and I believe, and I know for sure that judges are very proactive in this field, and they hold the positive position. And the judges initiated many initiatives. They had a peace or settlement room for people. So judges of administrative law are very positive about it, but the main thing is they shouldn't lose enthusiasm. They should be very energetic about it. And then later on we will see whether mediation really allows restoring mutual relationship between the parties, whether it allows reducing workload, and then we will see that it's public institutions that have to work on it and with it. And I just want to add that one mediation case doesn't mean minus one case before the court. Sometimes one mediation case closes several cases, administrative or civil or criminal ones that are heard before the courts. Yes, I believe it's the lawyers that should be resistant and could be resistant to mediation. That's why I wanted to find out what we could do when changing the lawyers' attitudes. Maybe we could make them see some pragmatic benefits in mediation. Well, I very rarely see the lawyers who try to hinder mediation. They always help mediation, and these are very few cases when they refrain from helping. Very often they do represent and do help mediators.
Okay, we are really coming to an end of our discussion, but there is a question from the audience about the civil disputes. The question is, are all the settlement agreements confirmed? From my own experience, I can say that there have been cases that the judges refused to confirm. In one case, the judge did not have to confirm the agreement because the parties have changed their mind. But the judge refused to confirm, but she was kind of at the very end of her term of office. But a new judge came in and confirmed the same agreement. So the question is, is the mediator allowed to discuss the issue with the judge? In my opinion, that does not infringe the principle of independence. You don't intervene, but you just discuss the issue with the judge, just in order to better achieve the decision. But this has been the case, but that's kind of marginal situation. So, Giedrius, concerning the settlement agreements, there are two cases. Once I had this kind of discussion during the training for judges, where the judges split into two groups. Claiming that if a settlement agreement covers more than the issues covered in the case, so some judges said we would not confirm it because that goes beyond the limits of the dispute. Because despite the regulation that mediation can address not only the specific dispute that is being addressed, but can address some more issues, but most judges would say that we would not confirm it because that is beyond the limits of the dispute. So there was no agreement. The discussion was really endless. Another case is when the judge refuses to confirm the agreement. Is that because the judge has some kind of belief, or maybe he wants to be curious, why the parties agreed concerning those terms, and for that reason we have the situation with numerous claims and complaints, because people complain that they appeal concerning the mediator, because they want the mediator to draw up the agreement that the court would confirm. And they claim that mediators don't work properly. Yeah, so that is a matter of discussion that we see they work maybe differently. But most often these judges don't draw up settlement agreement. First of all, because they don't have this obligation. On the other hand, they don't. They have an excessive workload. One more question to Egirius. What is the greatest challenge when you engage in mediation? There is a number of challenges. Maybe the greatest challenge is the parties. Sometimes the parties don't really want to agree. They are not sufficiently open. They are not sufficiently honest, and all that limits the possibility to reach an agreement. Because if people come just for the sake of coming to a conversation, that immediately is evident, and you see like two adults, educated people, and says that I would have something to propose, but if the other party does not propose anything to me, so I'm not going to do that. So I would like to say, just if you have something to propose, just let me know. But you just no, I want to hear the other party first. When engaged in mediation, I would pose certain requirements to myself, because every mediator perhaps has first mediation that fails. It can be a success story, but I remember my failures, because I keep thinking of what I could have done better. So that is a challenge for the mediator to develop professionally, to continue. So for mediator, work does not finish when the work is finished. So in my personal experience is to acquire trust, because that is the path to successful mediation, and not to jump to negative conclusions, because you can immediately feel very depressed and disappointed, but there is always another day. So I started my presentation from this idea, and I believe that maybe that fits to all mediators, that mediation is not about resolving a dispute, because if I believe that as a mediator, I need to reconcile the parties, and the parties will reconcile. Maybe that I will be feeling that I'm a bad mediator. Maybe I had studied too little. So mediator should think that mediation is not about resolving a dispute, and if we fail, we will feel true that maybe the parties have changed their views, and maybe if the parties came to mediation and managed to live together, so that is a great achievement.
Neturėkit iliuzijos iš karto susitarti. Nes iš karto pralošit.
General idea is that nobody should have illusions that parties will necessarily agree. Because if the parties don't, the mediator will be eating himself, thinking what has he done wrong. But everything sooner or later comes to an end. I sincerely hope that this conference was successful. Maybe it provided a lot of new information, insights, and everybody will have an opportunity to replay the material of the conference. So thank you to all the participants. And I believe that Lithuania mediation is still an example of success. And I would like to extend my gratitude to the audience and
susiję su ginčais, rinkitės visgi alternatyvas, neteisminį procesą.
Encourage everybody to look for alternative dispute resolution methods.
Ir tikrai galima spręsti tas, kas neperduota teismui, kaip sakė Vidijus. Ir tas daroma vos ne kiekvienoje byloje. O jeigu pasitaiko išimčių, jos sustiprina tą taisyklę. Ir jeigu teisminė mediacija ir nemokama, aišku, ir konfidenciali, taip kad turi labai daug vertybių ir gėrių.
If the mediation is extrajudicial, it's very confidential, so there are numerous opportunities. So today we were asking a question whether the courts are resisting mediation, but no, we are under the banner of Lithuanian Judicial Administration, so
Aš taip pat prisidedu prie sveikinimų ir pranešėjams, mūsų konferencijos dalyviams. Atskirai dar noriu padėkoti mano moderatoriai ir mediatoriai tuo pačiu Arūrui Driukui už nudirbtą darbą. Ir dar atskiras ačiū visai nacionalinės teismų administracijos komandai, be kurios pagalbos šita konferencija net nebūtų įvykusi. Tai ačiū visiems ir tikiuosi iki gražių kitų susitikimų.
Court administration and of next meetings.